All persons having business before the Honorable Chief Judge and Associate Judges now presiding over the District of Columbia Court of Appeals, draw near and give your attention. God save the United States and this honorable court. This honorable court's now in session. Please come to order.
Good morning, everyone, and welcome to the District of Columbia Court of Appeals, to our virtual oral arguments. We have three cases this morning. The first case is Melinda Roth et al. Versus DC Board of Zoning Adjustment. Are the parties ready to proceed? And I understand that two parties will be arguing on behalf of the petitioner here, and that you're going to be dividing your 15 minutes. Could you let me know who will be going first?
I'll be speaking first, Your Honor.
Okay. And will you speak, what portion of the 15 minutes will you be speaking for?
Just a short portion. Anything that I don't use, I'll hand over to my neighbor, Melinda.
All righty. Well, thank you. All right. We're ready to proceed. And I assume you all would like to reserve about 2 minutes for rebuttal following the intervener's argument. Okay. Thank you.
May it please the court, my name is Kimberly Panazzo. I'm here today to make you aware of how Call Your Mother has impacted our neighborhood. Since Call Your Mother has moved in, our worst fears as a neighborhood have come true. Our neighborhoods turn into a parking lot, cars pulling over wherever they see fit, including in front of fire hydrants, cars driving the wrong way down one-way streets on a regular basis, hordes of patrons of Call Your Mother sitting on private property, including hoods of cars and front steps of neighbors' homes to eat their food. Call Your Mother trash littering the streets, which has directly increased the rat population on our block. I want to make it very clear today that as a neighborhood, we are not here with a vendetta against the business of Call Your Mother, and we don't have a problem with the business of Call Your Mother. What we do have a problem with is the arbitrarily ignoring the zoning laws and allowing this business to move into a residential neighborhood and completely destroy the fabric of it. With that, I'd like to turn the remainder of my time over to my neighbor, Melinda, to further discuss the zoning.
Thank you.
Thank you. May it please the court. My name is Melinda Roth, and I'm here with my neighbor, Kim, as she just spoke, and on behalf of the 14 other co-petitioner neighbors. I'm a law school professor, not a practicing attorney, nor am I a zoning expert. And this is my first time in a courtroom, virtual or otherwise, beyond jury duty and a small claims court. We did try to hire over 15 law firms and lawyers who know zoning laws to represent us, but every single one of them cited a conflict of interest with the successful, popular, and extremely well-connected interveners. So please forgive me for any procedural or other mistakes that we may have made or that we may make now. But we understand that in front of this court, we need to talk about the law. And as we understand the law, this court defers to the agency, in this case, the BZA, unless plainly erroneous or inconsistent with the regulations. Only BZA decisions that are arbitrary, capricious, or an abuse of discretion or otherwise not in accordance with the law may be overturned. And you hit the jackpot because we have all of that here today. We've shown numerous errors by the agency and inconsistency with the regulations, all with the intent to grant this variance no matter the evidence. And BZA furthermore actually acted in direct violation of their own rules, section 11 from the code 11Z section 404. They actually denied me party status before the first hearing and then reversed their decision to grant it 2 hearings later, only after we threatened an appeal. They cannot do that, as the regulations clearly state in 404.15 that no person can request reconsideration of the denial, and 404.16 that if a request for party status is denied, another request for party status may not be made.
Can I ask you, does that that doesn't seem to directly address the authority of the BZA if it realizes it made a mistake to fix that mistake sua sponte, of its own accord. So could you, and it would seem like it would be better to allow the BZA, if it makes a mistake initially, to fix it rather than have the whole hearing go on and then later have the affected party or aspiring party have to seek review and get that done fixed years later. So why should we construe that regulation to preclude the BZA from realizing its mistake and fixing it itself?
That's an excellent point, Your Honor, but it prejudiced us because in the first two hearings, we were not allowed to cross-examine any of the witnesses, which they then later relied on to make their decision.
I get that point, and that seems to me a second different point, which is the BZA didn't really adequately fix its mistake. It was okay for the BZA to try to fix it, but it should have fixed it better. So that seems like a separate point. And let's assume for a moment the BZA could appropriately tried to fix its mistake, and the question is, did it adequately fix it? I get your point about the ability to question folks who were witnesses later, but is there a point in your briefing or in front of the BZA when you were kind of raising this concern where you indicated specifically what it was that you would have hoped to question those witnesses about and that and didn't have an opportunity to do so?
Yes, Your Honor, absolutely. There's one witness in particular, the representative from the ANC, that we were not allowed to cross-examine. Moreover, the later here.
Just to be clear what my question is. My question is, did you say in your brief, or did you say to the BZA when you were belatedly let in as a party, you haven't fixed the problem adequately. You need to reopen the hearing. I need to have an opportunity to question these witnesses. And here is what I would ask those witnesses. And here is why you need to do those things. Are those points that you made to the BZA in those specific terms, or that you presented in your brief in this court?
I believe that we made the first part of your question. We did not say, here's what we would have asked them had we had the chance to. We made it clear that by missing the chance to ask anything, we felt that there was, bias in the process.
You made it clear to us, or you made it clear to the BZA as well?
I believe both.
And do you now want to say what you think you could have realized had you been permitted that cross-examination?
Sure. I mean, this is the minor point. I would like to actually use more of my time on our core legal arguments, but this at the very least demands, we believe that at the very least, this needs to be remanded to the BZA so they can correct the problem and allow us full party status. The issue is that the third hearing, by the time I was named party status at the third hearing, they took the third prong of the variance off the table. It was a limited scope hearing. And so we had no ability to cross-examine any of the witnesses or evidence presented in the first two hearings about the purported evidence that there was a lack to the public detriment. We had a lot of evidence, we believe that there is. And so because there were only limited scope hearings, we had no ability to actually have party rights to discuss the third prong of the variance test.
Shifting to your legal arguments for a second, can I direct your attention to one of them, which is the question of how to interpret the corner store regulations. And I understand the point that you're primarily making about how to interpret the wording of subsection 13 and 14. But your opponents say, and the BZA seem to be persuaded by this, that the reading that you think should be given to those provisions doesn't fit with subsection 0.16, because if you're right about how to interpret 0.13 and 0.14, then subsection 0.16 just doesn't make any sense, doesn't have any function. And I know that there's like a brief sentence, and maybe perhaps in your reply brief where you touch on this, but I wondered if you could elaborate and try to explain because I'm not sure I've gotten it yet, how you think 0.16 operates, what its function is, when it applies, practically speaking, if you're right about how to interpret subsection 13 and 14 to mean that you always have to have a special exception unless you are a fresh food market or grocery store that can meet the requirements of subsections 13 and 14.
Okay, let me take my best shot at that. First of all, it's not just our view that the BZA is interpreting this wrongly. It is there's quite a bit of evidence. The interveners said that we only cited the zoning handbook, which is not law, but we can cite a number of sources if needed for your honors to be able to show that the only ones who see it their way are the lawyers and the BZA. In order to answer your honors question, the way that the law is set up, the plain language of the law, and we understand the regulations have to be read in the entirety. So 254.13 says that if you're a grocery market or a grocery store or fresh food market, you have the matter of right to open subject to these conditions. 254.14 says that a corner store use that is not permitted as a matter of right pursuant to 254.13 shall be permitted as a special exception if approved by the BZA, blah, blah, blah. The BZA actually processed another corner store that applied to be a prepared food establishment, just like Call Your Mother, and that establishment was required to have a special exception, just like the interpretation we're going to say. So to answer your honor's question about how 254.16 fits in, 254.16 says that except for 13 and 14, 13 being grocery stores and fresh food markets have a matter of right, and 14 being all other requests for relief, 254.16 says that all other requests for relief would be deemed variances. And that means relief in any of the other sections, such as the locational requirements in 254 section 6, or the signage.
To be clear, I mean, the section is 254, I think, not the subparts. Are you thinking that the word section in 16 means 254.16 only, or do you think it means all of 254?
The way that 254.16 reads is that except for 254.13 and 254.14, all other requests for relief would be deemed variances, right? I mean, that's what 254.16 says.
Yeah, that's certainly true. But my question is, do you read when it says meeting the requirements of this section? What do you understand this section to refer to? All of 254 or something different? That's my question.
Okay, so just have the actual rules up. 254.16 says, except for 13 and 14, an application not meeting the requirements of this section has to be the whole 254. There's nothing in 254.16 of substance.
I agree. And the reason I was asking that is you seem to be suggesting that the locational requirements were not part of the requirements of this section.
No, I don't mean to infer that. What I mean to say is that everything in 254.13, which specifies how 254.13 specifies the rights, the matter of right, ability for a fresh food market or grocery store with conditions. And then 254.14 says those that aren't a matter of right have to meet these conditions. But throughout the 254 section, before you get to 13 and 14, there's a whole bunch of conditions.
Right, but I guess
there's about 20.
I got that, but the problem is the 254.13a requires that in order to be as a matter of right, you have to meet the requirements of 254.5 through 12. And so I guess what I'm saying is, could you just give me a concrete example of a corner store that would, in your view, not be a matter of right, would not require a special exception and would only require a variance? Just give me an example of, what that would look like. What would be the features of it? Is it your view it's a corner store? Because the problem I have is if it's a corner store and 254, where is it now? Yeah, 254.14 says if you're a corner store use and you are not permitted as a matter of right, you're going to be a special exception. And so any corner store use that's not a matter of right is going to be pushed on your view into special exception. And I can't see how any of them would be pushed into variance on your view, which suggests that 16 is either just superfluous or something else is going on. And so can you just give me a concrete example of, I'm a corner store use and I am not a matter of right, but I don't have to get a special exception. All I need is a variance under 16. What would be my situation?
I think 16 is a blanket end of the section that anything that isn't under 13 or 14 would require a variance. I'm sorry, Your Honor, that I can't give you a concrete example, but I can say that 254.14, which the interveners accuse us of having a tortured reading over, makes no sense with their interpretation. Because if it's only for grocery stores and fresh food markets that don't meet the matter of right, then why would they have to have a description of proposed uses, activities, goods sold, or services rendered? Grocery stores and fresh food markets typically don't have services rendered. Every single authority, including the BZA in the earlier case that went under these corner store regulations called Creative Grounds, it's a coffee shop, every single authority, the zoning commission, when it made presentations to various ANCs, all news authorities, every real estate zoning blog available by search interprets the regulations, the corner store regulations, to state very clearly that only grocery stores and fresh food markets have a matter of right, and all other corner uses, barber shops, prepared food establishments, coffee shops, yoga studios, and whatnot would require a special exception. It's very clear, and I can cite all of the actual sources if your honors would like to hear them. There's quite a few.
Well, for now, rather than going on persuasive authorities, I think we just want to kind of stick to the language of the regulations to make sure we can make some sense of them. One answer you might have, but I haven't heard it yet, and I don't think I saw it in the briefs, is that maybe the requirements for getting a variance are sometimes more onerous. A use variance might be more onerous than the special exception laid out in point 14. So if you can't satisfy 13 or 14, you might have a route under a use variance, but you've got to show, exceptional hardship under, I forget exactly what it was. Is it 11.9, 11.10? Is to your knowledge, are there times where, you could get this, where if you don't, where it would be harder to establish grounds for a use variance than the special exception envisioned under 14? Does that make sense?
It does. And the other case that I've cited that the BZA processed, where the Office of Planning, OAG, and the BZA knew very well that this other applicant had to apply for the special exception, they also required several variances, which were all approved. So the new corner store regulations, which obviously have not, there hasn't been a case to this court about those regulations. They don't make it easy for a business to open in a corner store. They don't, because there's quite a few hurdles that one must jump through. And it's very unlikely that any establishment would meet all of the conditions and not require some kind of variance. The two other cases that have been approved by the BZA both required variances. One was already a grocery store, so it did not need to apply for a special exception under the regulations.
I had a procedural question for clarification. When the BZA initially granted the variance, you sought reconsideration before the BZA, and that motion for reconsideration was not granted. There's evidence in the record in the appendix before us of pictures and describing, I guess, some of the conditions that Ms. Penzano, Penzozo, excuse me if I mispronounced your name.
It's quite all right. It's Panazzo. It's a confusing one.
Panazzo, reference. Was that evidence that was available for presentation to the BZA at the initial proceedings where they initially granted the waiver, or is this evidence post hoc or following the grant of the waiver? In other words, was it available at the time that they presented to the BZA at the initial hearings and consideration for the waiver?
So as I understand it, Call Your Mother was able to open and had been paying rent from the very time that they applied for the very initial use variance. They, however, neglected to open, even though they said under oath that they could open as a retail shop, and they had the permission from the zoning administrator to do so because there was already a use variance existing on that property. They declined to open until the BZA ruled. So depending upon what pictures you're referring to in terms of the people aggregating trash, rats, etc., those pictures obviously come once the store was opened.
And was that evidence that you sought to present in your motion for reconsideration of the
Yes,
grant of the variance?
yes, Your Honor.
Okay, all right, thank you.
And is there a written order denying reconsideration, or was it never ruled on, or what? I looked at one point to try to find any written order and didn't see one. So I may have not looked thoroughly enough.
I'm actually sorry, Your Honor, I don't know the answer to that. I know that we filed this case before their actual ruling because we were of the belief that we could not seek any justice in front of the BZA, and that our only recourse was to seek justice in front of the Court of Appeals. And by justice, I mean application of the zoning regulations.
So you're saying you filed this appeal before the BZA ruled on your motion for reconsideration?
I was not the person who filed the case, believe it or not. So I think that it happened about the same time that or maybe exactly when the ruling came out. It was either like the day before, but it was clear from the hearing that they were not going to grant reconsideration. So the order actually came after the hearing, which it was clear that they were not going to.
Yeah, I did find
the
hearing where the motion was discussed. I just didn't know whether there was a written order of some kind, and I don't recall having seen it. I know I didn't see it. I haven't found it.
I actually do have the order, Your Honor. It was filed on August 5th, 2020.
Thank you. And I guess we can ask your opposing counsel whether that is in the record somewhere or whether it came out after the record was prepared. And I may just have the tabs in the record made it a little hard to manage, so I have not yet located it. Thank you.
All right, thank you. Ms. Roth, I will allow you to reserve some time for rebuttal, and we'll hear from the interveners at this time. Thank you. I'm sorry, Ms. Roth, did you have something else that you wanted to add?
I believe that the clock was set only for Kim, and it was set, I believe, at 8 minutes. And then when it went out, it hasn't reset for the 8 minutes.
He reset it
So-
about halfway through and you've now had 25 minutes.
Okay.
Yes, he did. He did reset it. But did you want to take a brief moment to conclude your?
That would be very helpful. Thank you very much. So I believe we talked a little bit about the corner store regulations and the misinterpretation of the corner store regulations. But in addition, we haven't talked about the variance test and the 3 prongs, which we have established evidence that the interveners do miserably fail the 3-prong test. I do not believe I have time to go through it. And I do understand that the BZA has the ability to weigh the evidence. And it's not just that they didn't like ours or believe ours. It is that all of the evidence in the record from the other side is opinion and misstatement. And there is no concrete evidence of the meeting the burden of proof that an applicant needs to meet those 3 difficult prongs. We believe they fail each prong. There is nothing unique or exceptional about the property, and we believe that we submitted actual evidence to that effect. There is absolutely no practical difficulties for the landlord, and we believe we submitted evidence to that effect, and the applicant only said they think it might be hard to rent it to someone else. And then finally, we believe that it is laughable that the BZA could claim that there's no detriment to the public good. There is more than sufficient evidence in the record that proves that there is absolute harm to the public good, including the fact that the BZA ignored their own precedent of not approving previous variances applied for on the very same block for delis and prepared food establishments. And the only rebuttal that the interveners give is that those cases were old, that the zoning regulations have changed. And that is absolutely true. The cases are old. The zoning regulations have changed. But what hasn't changed is the definition of substantial harm, substantial detriment to the public good. The noise, the people, the parking, the trash, the rats, all of that, which was the reason for denying those variances in earlier cases, exists in this case. And that is proof of the BZA's arbitrary and capricious decision-making when they ignore their own cases in order to grant this variance because of who the applicant is, not because of what the evidence is. Thank you, Your Honors.
Thank you, Ms. Roth. We'll hear from the interveners now. Thank you.
Thank you, Your Honor. May it please the court, Cynthia Gearhart on behalf of the interveners, 3428 O Street LLC and Call Your Mother Deli. For over 100 years, this property at 3428 O Street Northwest has operated as a commercial use in a residential zone. It was purpose-built to be a corner store. Prior to 2016, it required a use variance to operate commercially, which it had done most recently under a retail use variance from 1973. But because of a change in the law in 2016, for the first time, it was allowed to operate as a corner store as a matter of right in a residential zone, provided that it met certain conditions. And of the roughly 20 conditions in the corner store regulations, there was just one that it didn't meet, which is that it was located within 750 feet of an MU zone. So the property therefore needed a minor area variance to allow it to operate for its intended use as a corner store. So in a thorough and well-reasoned decision that is amply supported by the record, the BZA properly granted the area variance, allowing the property to operate as a corner store.
Since you refer to it as thorough, let me test that for a second, because it doesn't say anything. It doesn't give any analysis on the regulations. It basically says it agrees with you that, point 14 only applies to the same markets, the fresh food markets that are referred to in point 13, which is a very odd reading of the regulations. And so I wonder if you want to offer some defense of that.
Sure. I mean, as far as, I guess you're asking about whether regarding the special exception and that question that.
It looks, as I read the regulations, it said 0.13 says fresh food market or grocery as a matter of right if they can meet some conditions. If it's not that, and it's a different kind of corner store, then special exception if you can meet these exceptions. If you can't meet either of those, then you've got 16 and you're a variance. And you'd need to satisfy some use variance requirements. So that's how I read it. And you read it differently. And I guess I just want to, but the BZA doesn't really explain itself. And so I'm wondering if you could explain what sense 0.14 makes if it's only referring back to the 0.13 fresh market groceries, contrary to the pretty plain language of 0.14.
So the BZA consulted with OAG in determining whether a variance was required in this case to meet the corner store regulations. And so either way, you can read the statute two different ways. And obviously the BZA and interveners read it one way, that is allowed as a matter of right, and the petitioners read it another way. But either way that you read it, either way we need a variance because there's one condition that we don't satisfy. So if it's that you can proceed as a matter of right, you can only do that if you meet all the conditions. Or if you read it the other way where you might need a special exception, you still need to meet all of the conditions to qualify for the special exception. That's a requirement for the special exception. So either way, it's really not a question for this court because it's sort of speculating as to what we would have done if we had met all of the conditions. Could we have gone matter of right? Would we have needed a special exception? Is really not a question because either way, we needed a variance because anytime you're seeking a use that's not permitted on the face of the regulation, you require a variance.
Well, that's a very complex point, and I run aground on one aspect of it pretty quickly, which is maybe that's right, maybe that's not right. But in fact, the BZA purported to decide the question. So, I mean, it could have been, you could have said, as you did with whether you're within 500 feet of other grocery stores, you could have said, maybe that's a disputed issue, but it's not the BZA's homework today. The BZA only needs to figure out, we think we have only one problem and one variance will solve our only problem. And that's what we've asked the BZA to do. If we're wrong and there are other problems and we didn't get an adequate variance, then that'll come up again down the road and people can fight about it then. And that's what was done. And that's the way the BZA interpreted. That was the argument you made. The BZA accepted that way of looking at that aspect of the case. But on this question of whether a variance suffices or whether instead you're required to get a special exception, I didn't understand you to be taking the position that that wasn't the BZA's homework today, in this case. And in fact, the BZA decided it. And I also think in your briefing in this court, I don't recall the point that you just made, which is it really doesn't matter. Nobody needs to decide that question. Why doesn't everybody duck it and postpone it to another day, like whether you're within 500 feet of the grocery store? I didn't see that in your brief. So it's coming up a little bit late, and it has the problem that the BZA did actually decide the question, it seemed to me.
The BZA discussed it because petitioners repeatedly brought up the argument and they always wanted to review, consider all of the arguments raised by the petitioners. And so that was the discussion, but I don't think that their opinion relied on it necessarily. But there is support, and we can discuss, for the finding that that corner stores are allowed as a matter of right.
Before you get to that, let me just make sure I understand the substance of the point you're making, leaving aside its procedural complexities. Are you kind of accepting the premise of Judge Deal's question to your opposing counsel, which is the way these fit together? Well, your lead argument is 2513 and 2514 only apply to fresh food markets and grocery stores. That seems like a pretty difficult argument. But your fallback argument is, even if that's true, at the end of the day, all you will need is a variance, because the way they work in this alternative view, that's your fallback view sort of, is if you're a corner store, and you can try to say as a matter of right under 2513. If you fail that, you could try for 2514 and say, not a matter of right, but I can get a special variance. And if you fail that, then you have as an option, a special exception. Then if you fail that, you have like 254.16 is your third option, which is you could just try to get a variance. Is that a premise of the point you were just making, which is that either way, people wouldn't have to decide this question, because either way, at the end of the day, if you can get a variance, you're entitled to go ahead with this project. Am I right? Is it a necessary part of that chain of reasoning that Judge Deal's suggested way of possibly looking at it is the kind of the right fallback way of looking at it?
I think that's generally right. I don't know that it necessarily has to go into the steps as much as just we looked at this. There's a condition that's not met on the face of the statute. The applicant says they don't meet this condition. Therefore, you need a variance. Anytime you don't meet a condition of a statute, you need a variance. You can't get a spec. So it's not so much that you do an analysis, go through matter right, and then you do another analysis, as much as which the BZA did, and they consulted OAG at the hearing and said, we need a variance, right? There's a locational requirement they don't meet. That's an area variance. OAG said yes. They said, okay, we're going to look at this as an area variance.
Because the BZA didn't get very specific about why it agreed with your position that 2513 and 25413 and 25414 essentially apply only, both of them apply only to fresh food market / grocery stores. It certainly didn't kind of get into or discuss how does that fit together with other provisions, including 254.16 or 254.2, which, again, 254.14 refers generally to corner store uses, not just fresh food markets and grocery stores. 254.2 defines corner store use quite broadly in ways that obviously run beyond fresh food markets and grocery stores. Your opponents make the point about 254.14 that seems to be asking for things that don't fit that well with the idea that that provision is limited only to fresh food markets and grocery stores. So we don't have much help from the BZA about whether, for example, the idea that Judge Deal has raised would work or not work. And I'm not sure whether it does or doesn't. I don't mean to suggest anything more than other, but I guess I'm puzzled about one aspect of it. If 254.14 says if you can meet certain exceptions, then you can get a corner store use approved as a special exception. Unless all of those requirements are more lenient than the variance requirements, if 254.16 is just like Plan 3, then it seems like Plan 3 might be easier than Plan 2. And maybe that's fine, but it just seems it might be if variance is generally pretty easy to get. And 254.14 seems to be like, well, if you're going to be a corner store and you're not permitted as a matter of right, you're going to be okay, but only if you can meet a bunch of special exception requirements and conditions. It would be kind of odd that there'd be that strict set of requirements to be eligible under the second route. But then under the third route, it's just like, variance. Now, maybe that's not as hard. Maybe it is less hard. I don't know. But it just seems a little unclear that that's a sensible way of fitting them all together. And certainly the BZA hasn't told us that's a sensible way of fitting them together.
A variance is a stricter burden, and this court has held that, in fact, said it is a special exception burden is, quote, much lighter than the use variance test, which was in Georgetown College, a 2003 case. And so to seek a special exception, all that is required is that the party go to the BZA and say, I met the conditions of the statute, and it is the BZA is obliged to approve. That's a quote from another case recently, the Lamb application case.
That's very helpful. Can I ask you one question about one of the consequences of the complicated point you suggested in response to Judge Deal? Is it is one possible upshot of what you said, that you would have no objection, or maybe this would be what you would ask us to do if we said, we're going to set aside the BZA's discussion of whether a special exception is required here or whether a variance is enough. That's not today's homework. All the, the interveners, whether correctly or incorrectly, said all we want is a variance, and we'll find out down the road whether that will solve their problems. Would you have an objection to that, and do you instead want us to agree with your primary submission about how to interpret these that the BZA accepted, which is actually these provisions 254.13 and 254.14 apply only to fresh food markets and grocery stores?
We don't have any objection to that, and I'm certainly, and again, and I could go through why the argument is supported that 13 and 14 only apply to grocery stores, but I don't think it's a necessary exercise to go through that, because it really wouldn't change anything. We could go back to the BZA and say you need a special exception, and we'd say, well, we don't meet a condition, you can't get a special exception, you need an area variance, and we'd be right back here. So it really is kind of a distraction, and the board got involved because petitioners kept repeating it. So the board was trying to respond to petitioners' arguments, make sure they were heard and responded to, but it's truly not the situation that we have. Because
in fairness to the board and to the petitioners, though, it's not as though, at least as far as I have seen in your briefing in this court or in the arguments made in front of the BZA, it's not as though the interveners were saying, don't address this question. This question too is premature. Nobody was telling the BZA that's not your homework right now. Or did I miss something?
No, I don't think so. I think the BZA is always careful to hear all issues.
My point is not about the BZA. My point is about the arguments that the intervener was making to the BZA. My question is about that. Did the intervener ever say to the BZA, as it did about whether there are too many grocery stores nearby, don't get into that. That's a distraction, as you mentioned, as you were suggesting, the variant special exception issue was that ever argued to the BZA? You don't need to decide that question. That's a distraction.
I think intervener was focused on defending that it was an area variance. So just saying, an area variance is required here, that was the thrust of intervener's argument to the BZA.
So are you agreeing that argument was not made to the BZA?
I'm not entirely sure.
Just so I understand it as a practical matter, in your view, so let's say we agree that the area variance was appropriate, but that to operate, you needed a special exception. And let's just posit that we say, okay, maybe that wasn't necessary to the BZA's decision here. What's the next step? What do you think the appropriate avenue for them to challenge, hey, these guys are operating without a necessary special exception is? And why wouldn't we just ask the BZA for its opinion on that matter, where it seems like it's eventually going to have to offer it?
I'm not sure I'm understanding the question. Is it?
Let's say, so the question of whether or not Call Your Mother needs a special exception has come up. And under the regulations, it seems to me that it probably does. But you are saying, that wasn't necessary for the BZA to decide. We just asked for an area variance. Just say the area variance was okay. If we said that, what is the correct avenue for these petitioners to say, hey, Call Your Mother is operating without the necessary special exception? Does it just go right back before the BZA?
So I think it wouldn't get there, because by determining that the area variance is a tougher burden, they have to show practical difficulties, which they wouldn't have to show under a special exception. So by obtaining the area variance, a special exception is not necessary. A special exception is sort of a lighter burden that they wouldn't.
Why do you think you only need an area variance? Why don't you think you need a use variance if you don't satisfy 0.13 and 0.14?
We don't need a use variance because the use is allowed as a matter of right. The use being food and drinking establishment is allowed as a matter of right. So that's why we don't need a use variance. The area of it previously, and I should just clarify in case there's any confusion, previously they needed use variances until 2016. In 2016, it became an allowed use to have eating and drinking establishments. You can't cook on site, but you can do food preparation and reheating, and that's in the corner store regulations. That is
Yeah,
allowed.
except what the corner store regulations say is it's a matter of right under 0.13 if you're a fresh food market. It's a special exception if you're not a fresh food market in a corner store and you can meet certain exceptions under the special exceptions required there. And if you're neither of those, you're right back in a variance. And my question is like, why isn't that a use variance?
Because none of the conditions don't touch on use. Conditions are just, that you've met locational requirements, that you don't sell alcohol, that you're no larger than 1,200 feet. None of that is use. The use is permitted. It's not. They're not talking about determining whether a certain use is allowed or not. The use is already permitted. So
Can I ask another way of getting at getting at one of the aspects of Judge Steele's question is the following. With respect to how many grocery stores are nearby, the argument was, which the BZA accepted, is that's really the BZA doesn't have to decide that. If you get a variance and that variance doesn't conform with the requirements of the use, that can get sorted out down the road. And can you just say practically, how does that happen? So let's just focus for a minute on the simpler setting of whether there are too many grocery stores nearby. Your argument to the BZA was, don't decide that now. Give us only the variance we want. And if somebody doesn't like it, that can be decided later. How does that get decided later? Is that when you apply? Is that when someone comes in and then brings an affirmative? The petitioners come in affirmatively and they say, BZA, you approved people to have variance A, but in reality they are acting unlawfully because although variance A means they don't have that problem, they have another problem and they didn't get a variance for that, and so you need to shut them down. Is that how it happens practically, or how does it happen practically?
Sure. And I think you're referring to the self-certification process. So we self-certified that we met all of the conditions except for the one. And the way that works is, and this court has upheld it, this process is by regulation. Self-certification is under 11Y 300. It says that you are permitted to certify. The BZA is conditionally approving it, subject to the zoning administrator then going through and making sure you satisfy the conditions that you said that you satisfied. That happened here prior to obtaining a building permit. If the zoning administrator issues the building permit, petitioners could have appealed the zoning administrator's issuance of the building permit. That's where we would be talking about we're located within 500 feet of another corner store.
Got it. Very helpful. I got that 100%. Let me just ask you, does it work the same way if the complaint is a variance is the wrong beast, what was required was a special exception? Can that also, by the regulations, is that something the zoning administrator would be tasked with figuring out after the fact here, and that there would be an opportunity to seek review of a determination of the zoning administrator? Or is that not really on the zoning administrator under the regulations? Is that not really on the zoning administrator's to-do list?
I think that was determined by the BZA here. And just to reference, the court has noted before that especially when determining what variance, whether it's a use variance, area variance, or something else, the court gives great deference to the BZA on this because it is complicated. It's not always simple. It's usually not black and white.
The reason I asked the question I asked about whether it works the same way with respect to whether a special exception is required or a variance would suffice is you've been suggesting it's a distraction and that you don't have to sort any of that out. But if the board, the BZA did sort it out. But leaving that aside, if that's been determined now and there's no later process for anyone else to determine it, then it seems like we have to determine it and review that determination. Not determine it, but review that determination. Because if we don't, who will? When? So it seems like it's not a distraction. It's something we have to decide.
The case where you would determine that is if a corner store said, I meet this as a matter of right. I go to the zoning administrator, I get a building permit. And then the neighbors say, no, you needed a special exception. You weren't allowed to do that as a matter of right. That's the case where this court would decide that.
Well, let me ask you, let's say we took your suggestion or one of your alternative suggestions and wrote an opinion that on this issue said the following. The parties have been arguing about whether a variance is required or a special exception is required. The BZA decided that question, but we've been persuaded that that's not something that needs to be decided now. The applicant, sort of like the proximity of other grocery stores, the applicant thinks a variance is enough. That's all the applicant has gotten. And if the objectors think it's not, then at a minimum, if a building permit is issued, although I'm not sure a building permit is needed here because they're already, so I'm a little unsure about the exact remaining steps. But is your suggestion that there would be steps in front of the zoning administrator? In this case, if we accepted your suggestion that that's a distraction for right now, where the objectors would be able to tee that up? Because that was, I think, Judge Deal's original question, or, was assume that we don't decide the question. We sort of set aside the BZA's determination of whether a variance is enough or whether a special exception was required. What would be the process by which that issue could be teed up later, or determined later by a zoning decision maker, and teed up for review by the objectors if they didn't agree?
I mean, I think you would need to appeal the decision of the decision maker who made the decision, which, I mean, the BZA determined which use or which area variance. I mean, the zoning administrator ultimately approving I don't know if it's building permit or a license to occupy the space.
Can I ask you, I know we're well over time, and there's one issue I have a question for you about that is with respect to the requirements, the 3 variance requirements. And that's on practical difficulty. And one of the points your opponents make is that the BZA didn't really zero in on the practical difficulty question quite right, because the question is practical difficulty for the owner. Practical difficulty for Call Your Mother is not germane directly. Maybe if it wraps back around to practical difficulties for the owner, then maybe, but it's not directly the relevant inquiry. Can I first ask you, do you agree with that the question on practical difficulty is practical difficulty to the owner, not in and of itself practical difficulty to the tenant?
I don't necessarily agree, because the owner can authorize the tenant, and this court has supported cases where the tenant was the applicant proceeding before the BZA, and that's permissible under the regulations for the owner to authorize somebody to act on their behalf. And then I would like to go to, I think, what is going to be the second point, which there was harm.
Before you get to the second point, I'm not sure it follows that an owner can authorize a tenant to be an applicant, that the inquiry into practical difficulty then shifts from the owner to the applicant. I mean, that the first procedural point doesn't, to me, necessarily answer the question one way or another about whose practical difficulty the applicant needs to identify.
I mean, I think the difficulty for the tenant is the difficulty for the owner, because if the tenant can't pay rent, then the owner is in a 10-year lease without a rent paying tenant. So that was the point of having the tenant show.
Well, I get that. That's a different line of thought. And that is the idea that if I am an owner and I've rented and I've leased to a tenant, that it won't be able to pay me rent unless the tenant can get unless the property can, variance can be granted for the uses of the property, the activities of the property. I get the idea that then that can wrap around to practical difficulties for the owner, but that seems like that's a separate point. And then the issue would be, okay, let's try to figure out then what did wrap around and what's the evidence here. And so what is the evidence that if no variance was granted, Call Your Mother would likely default on the lease?
Well, that 59% of Call Your Mother's revenue is bagel sandwiches, and without the variance, they wouldn't be allowed to do the reheating, food assembly, and prepare bagel sandwiches. So that's 59% of their revenue.
Well, it's a little simplistic. That's a little simplistic, because that suggests that if they weren't allowed to prepare sandwiches, they would take no other steps to, give people, do-it-yourself sandwich materials or whatever. So it's probably a little simplistic to say that if they can't do what they want to do, then, you would just subtract that from their activity. That seems a little unclear, but leave that aside. And what does that tell you about whether Call Your Mother as a corporation would default on its lease?
That was the evidence presented to the BZA, that would be a difficulty. And the practical difficulties, you don't need to show impossibility. You don't need to show undue hardship, which is under use variation. You really just need to show that it would be difficult. And the court has held that economic difficulties can be that proof of difficulty.
But what's the economic, unless there's a default by Call Your Mother, I don't see any economic difficulty, at least during the period of the 10-year lease, to the owner.
There were also physical characteristics of the building. They talked about whether they would need to retrofit the building for another use.
Well, no, but I just here one way of looking at it is if the inquiry is, I know you don't necessarily agree with this, but assume for a moment the inquiry is, what is the practical difficulty to Call Your Mother? Not, I mean to the owner, not to Call Your Mother. The owner is sitting on a 10-year lease with a corporation. And unless there's going to be a default, none of the rest of it is going to have any difficulty for it. It's, maybe it's, unless there's going to be a default, it may be that Call Your Mother will have various problems. But unless there's going to be a default, it's no problem to the owner.
It's 60% of the revenue of the business's revenue would be lost if they can't.
But again, if I've signed a lease and then I lose, I mean, Call Your Mother operates at other locations, or is it a corporation that was going to operate only here?
They operate at other locations.
And so let's say that it signed a lease, and because it didn't get a variance first, and it didn't get a variance, tried to get a variance and failed, it was going to be a lot less profitable, and that it was going to lose money on this lease. What's the evidence that it would default rather than it would suffer losses as a corporation, but it would actually default? And even then, unless the owner, I guess the owner would have the economic difficulty of having to recover the lease in a breach of contract action rather than getting paid. And maybe that's economic difficulty, but I'm just not quite sure there was evidence that there was any risk that Call Your Mother would actually default on the lease. And if there wasn't, then I guess I'm a little unsure if the inquiry is only injury to or practical difficulty to the owner, what that practical difficulty was.
The evidence was in the form of credible testimony, and the court has held that you don't need to support that testimony with studies and surveys. I think the BZA.
What was the content of the testimony? What evidence was there that there was a risk that Call Your Mother would default on the lease?
That 60% of its business would be lost if they weren't allowed this use.
But that's inference from the testimony that it would be less profitable. It would have less turnover than it would hope. Or is there something more direct, or is it just inference from it would have a significant reduction in turnover?
I think it's more than inference. It's.
And did the board draw that inference? Just so when the board says, here is the practical difficulty to the owner, the practical difficulty is that there's a significant risk that Call Your Mother will actually default on the lease, and that's a problem for the owner. Is that the mode of analysis in the BZA's opinion?
That was one factor, but that was exactly stated, and then there were other factors.
But so they talk about defaulting on the lease. The BZA does.
I do believe it did. It was the testimony that the tenant needs to pay rent, and if the tenant can't pay rent, then in a 10-year lease without a rent-paying tenant, that was in the BZA decision. Did we want to touch on party status briefly? I know I'm out of time.
Well, yeah, I guess I would see. What's your response to your opponent's argument that this was fixed too late, and that your opponent was prejudiced because there were witnesses and issues that had been previously addressed, that they were kind of unfairly limited in their ability to address at the earlier stages of the hearing?
So the BZA proceedings essentially restarted at that third hearing. So that was the first hearing where they were discussing the area variance. So, and they had said, the board wants to ensure that the new relief is fully vetted. That was a quote. So they were essentially starting from scratch. Ms. Roth specifically had 7 submissions before the board. She did testify at the prior hearing. She had a PowerPoint ready to go on December 11th. She cross-examined the applicant Office of Planning, witnesses. Her concerns were duly noted by the board. There was no missed opportunity for her concerns to be heard by the board. The board spent pages and pages of its order discussing her concerns and the other petitioners' concerns. So there was no prejudice to the parties, and they essentially restarted on that third hearing day because that was the first day they were talking about the area variance. So it was essentially restarting the entire proceedings. May I briefly conclude? For all of the reasons that we discussed previously, the BZA granted a minor area variance for this property to operate as intended as a corner store, and we respectfully request that the court affirm the board's decision.
Thank you, Ms. Gerhart. Ms. Roth and Ms. Panazzo, did you each want to take a brief minute or two to share the rebuttal time, or Ms. Roth, were you going to do the rebuttal?
Kim, is it okay?
I'd like to hand it over to Melinda.
Okay, thank you.
All right. Thank you, Chief Judge. Okay, I'll try and do this as quickly as possible. I'll start with the last issue. Ms. Gerhart was actually not at the third or fourth hearing. She represents only in the appeal process, and the hearing did not restart. That is a absolute false characterization of the hearings. It was a limited scope hearing where the third prong of the variance was not supposed to be discussed. The amount of submissions.
So you said that a few times. Can you just point me to where somebody said we're not going to get into the third prong?
I believe the transcripts, when they talk about holding the next hearing, specifically cite it is a limited scope hearing. And Chairman Hill still allows he still allows anybody present to testify, but the testimonies had to be only on the limited scope.
But you don't have a citation for me.
Do
you know which hearing?
It would have been after the second hearing, because that was when they determined it would be a limited scope hearing going forward. I also want to mention that council talks about the OAG saying that they only needed the variance, and that is also a false characterization in the transcript from the second hearing when they recommended a lower form of relief would be to seek an area variance under the corner store regulations rather than the original application, which was for a use variance. The OAG said, come back to us and tell us what you need relief from. They never said that you do not need a special exception. And all of this that you discussed, you have to say that I'm, happy that the judges seized on this issue, because this has been a very clever way to circumvent the regulations. This is not something that is only under the purview of the zoning administrator. The BZA knows that non-grocery stores and non-fresh food markets must seek a special exception because that's how they processed an earlier case. And let me start over. They don't need just the special exception according to the corner store regulations. Because of the 750-foot rule, they also need an area variance. And so this is not something that should be put off or not decided. This case was supposed to decide both, and BZA did. BZA erred in their decision by claiming that they didn't need a special exception that they can open as a matter of right. And that, we'll pass the potato to the zoning administrator. And all of this is a very clever way to circumvent the regulations and give Call Your Mother the variance that they sought when they needed to seek a special exception and the variance. We don't take issue with the fact that self-certification is allowed, but going back to the variance and the three prongs that are required, Mr. Dana, who is the owner of Call Your Mother, he's on the record saying that there would be no decrease in traffic if they opened as a retail store.
Ms. Roth, you say you don't take issue with the intervener's self-certification? Or you don't?
What I meant, yes,
with
but I'm sorry, Your
Yeah.
Honor. What I meant by that is that we understand that self-certification is allowed as a process.
And what was it about the self-certification here that you take issue with?
We take issue that they say that they met all of the requirements because they keep interpreting the regulations, the corner store regulations incorrectly, that they can open as a matter of right and therefore don't require the special exception. If you read the regulations properly, not only do they need the special exception, they then have to meet requirements, and they do not meet these requirements. That's why they papered over this whole thing that they don't need a special exception, because they do not meet the requirements.
But which
And
requirements?
it would require additional variances, which we're not sure. We believe they would never be able to obtain given the evidence in the
Well,
record.
Can you just point me under 254.14 B? It's got all the different requirements for the special exception. Which ones don't they satisfy?
A corner store shall be located so it is not likely to
I see.
become objectionable
All
to
right.
neighboring property. We can start there. There's others.
Yeah, that doesn't do you much good because that's already baked into the variance, or the variance hearing that the BZA has already.
Okay,
supplied.
they
So
also-
it's kind of a reiteration of that argument, just in different clothes.
Fair enough, but it's very specific of because of noise, traffic, deliveries, or other objectionable conditions, which the two adjacent properties are part of our petition. The two owners of the adjacent that share walls are actually part of this case. But if you look at 254.14B, 1 says that a demonstration of conformity to the provisions of 2545 through 12. So you go back up to all of the other conditions that they have to meet. And if you look at 254.6, that actually the only variance that they sought was for the 750-foot rule, which is G. But they would also then have to meet, let me make sure I have this right. They would also have to meet C, not within 500 feet of more than 3 other lots with a corner store use, defined as retail, general service, or arts design and creation uses. And we have in the record that there are 5 corner store uses within 500 feet. And they tried to get very clever and argue, oh, those aren't corner stores under the corner store regulations. Well, at that point in time, only 2 establishments had been processed under the corner store regulations. And moreover, in those 2 previous cases, both the BZA and the Office of Planning recognized other stores that were within 500 feet, whether they were on corners or not, and certainly had not been processed under the corner store regulations. So in other words, they would need a variance from not meeting that requirement because they are within 500 feet of 5 different corner store use locations.
Ms. Roth, I would encourage you to please wrap up your rebuttal because we've been very generous with your time today. Thank you.
We could not appreciate more your generosity, and I just believe that there's more than enough evidence in the record to have this court overturn the decision that the BZA made. It was erroneous. It's inconsistent with the regulations. It establishes a brand new standard for getting a variance, which is all you have to do is tell us that you have difficulties, and that's enough. With all due respect, at the very least, because of this party status issue, if the decision is not overturned, it needs to be remanded back to the BZA so that we can have all of the rights and that should be given to a party in order to not have any prejudice against our case. Thank you very much. On behalf of Kim and the other 14 neighbors that we represent, we are very grateful to be here today.
All right,
Thank you for your time.
Thank all parties and counsel for your arguments today, and we will take the matter under advisement. Thank you. And you're free to exit our virtual courtroom at this time.
Thank you again.
Counsel for your.
Good morning.
All right, good morning. This is the second case on our calendar this morning. Kelby Gordon, United States. Good morning, counsel, and are you ready to proceed at this time?
Yes, Your Honor.
All right,
Mindy Daniels for the appellant Kelby Gordon, and I'll reserve 3 minutes for rebuttal, please.
all right. Ms. Daniels, could you give us 1 second while we reset the clock for this case? Okay, there you go. Thank you.
I see the clock. Okay, thank you. We presented a lot of issues. I know we're not going to get to them all. I would like to start out with our first issue, which was what we claim was other crimes evidence from the videos, text, and testimony of Detective Quigley, and then move on to issue 4 in our brief, which was Detective O'Donnell's testimony. And
Ms. Daniels, if I could, and this may be one of the issues you were going to focus on, but I would appreciate if you could start out focusing us on the AWICA, assault with intent to kill, and whether or not there was sufficient intent under the concurrent intent, transferred intent theory.
right, because they didn't go on concurrent intent specifically. They said that. With the AWICA, in terms of where, so this involves Ms. Morris, which was, according to the Detective Washington's testimony, was 100 to 150 yards away or 2 or 2.5 blocks away. So a bullet goes through her apartment window, lodges itself wherever. She was unharmed, however. So, she was not your typical bystander. She was unharmed. She wasn't in a line of fire like in other cases where you're shooting at a car. There are other people around. There's another car.
Can I ask about it? She was sort of in the line of fire. It may be that she wasn't visible in the way that someone who was outside would be. But just to simplify a little bit, I understand some of your points are about the particular circumstances of this case, but if you make some of them easier, I just want to make sure how broad your arguments are. So if a defendant is shooting at person number 1 and person number 1 is standing in front of a window of a residence, and the defendant, fires at person number 1 and misses. And someone happens to be in the room that is, out from which the window faces and is hit, first of all. In a case like that, would you think the evidence would be sufficient to convict the defendant on a transferred intent theory that the defendant intended to kill or shoot and kill the intended victim and missed and foreseeably could have understood, although the defendant didn't see, let's assume, that there was someone behind there. The defendant should have foreseen at least that someone might be back there. Is a scenario like that sufficient, or do you think that even that's on the wrong side of the sufficiency inquiry?
I would say that that's by case law been found sufficient because even though they were unseen, they were nevertheless directly in the line of fire and with a zone of proximity. That's similar. Your example is
one more step down. Imagine in my hypothetical, the first one, the occupant of the residence was actually hit. Assume instead that the bullet went whizzing by and missed the occupant of the residence by an inch.
Mm-hmm.
Would you say that's on the wrong side or the right side of the sufficiency inquiry?
I'd say that's closer to sufficiency. And in fact, The examples that Your Honor just gave are similar to the Williams case. And actually, I think the Lloyd case as well. In Lloyd, a bullet went through one person and then actually, killed that person and then killed someone else. In Williams, the first example Your Honor gives, they missed the target and they kill a bystander. But even then, I would say even then, let me qualify this. Even then, in the Williams case, 881A second 557, there are two Williams, when the bystander is killed, they're found guilty of second-degree murder and ADW. There was no AWICA.
We don't have any cases that I'm aware of in our jurisdiction where an unintended victim is unharmed. This scenario here seems one step removed from Williams. And I'm aware of a Maryland Court of Special Appeals case, Harrod and Harvey, where they looked at this issue and found insufficient intent where you had an unharmed, unintended victim. But as far as I know, there's no case directly on point here in DC. Are you aware of other cases?
Actually, I was going to say that my best case is that there's no case
Mm-hmm.
where a WICA was found. And at most, in any of these scenarios, it became an ADW. And even with the multi-car case, where, they're aiming at one car, then that aimed at car, if they didn't get killed, became an AWICA. But the unaimed at car, even though nearby, and even their the occupant of the car that was the intended victim was a WICA. The unintended victim became an ADW.
Ask you one other about a simpler unharmed victim case. Imagine that somebody was really mad at me and wanted to kill me, and saw someone who they believed was me walking down the street, and took out their gun and shot at me and missed. Or shot at the person they believed was me and missed. And it turns out it was not me. It was someone who looked like me. But I'm unharmed in the sense of, an assault victim is harmed in the sense of being the victim of an assault, not physically harmed in the sense of being hit by the instrumentality of the assault. But in that case, do you think transferred intent would allow an AWIC charge, assault with intent to kill, on the theory that the victim who was unharmed other than by the assault, a charge could be assault with intent, assault on that victim with intent to kill me? Would that transferred intent work or not work?
Are you on the scene?
No, I'm nowhere to be seen. I'm just the poor victim was mistaken for me, and I am on vacation in Hawaii.
That's closer. There was, whether it was you or someone else, then to me that's a clear assault with intent to kill. Or did they kill the person?
No, they missed. The bullet goes whizzing by. Luckily, the bullet goes whizzing
even
by.
the person that they don't know.
Exactly.
It depends on some circumstances of how the shooting actually occurred, but they walk right up to the person, try and shoot them, and they just have horrible aim. Then, I think that you can establish an intent in that case. And they're certainly in the line of fire.
Because on the hypothetical, the intent is not to kill the actual victim of the assault with intent to kill. It's someone else, and you would say that intent can be transferred?
I think in that particular hypothetical, probably it's right
Are you
there.
sure you want to say intent can be transferred instead of, you just intended to kill that person under a mistaken identity?
Right. That's why I'm struggling with this a little, because I don't even think that would be a transferred intent.
You very much intended to kill the target under Judge McLeese's hypothetical, right?
Right.
Just had a mistake about who they were.
Exactly.
I don't think intent to kill requires that you appropriately identify the person who you're aiming at. Is that your answer, or do you want to say that that's a transferred intent example?
No, I agree with what you're Honor just said without taking the time to repeat it.
So tell me a little more about the circumstances of this case and why you think there was no transferred intent or intent for a WICA. And if you're familiar with the Maryland case that I mentioned, I'd welcome your thoughts on the analysis in that case.
I have to admit that I'm not familiar with that case, but I think it was the right result.
They said one quote is the absurd result would be to make one criminally culpable for each unintended victim who, though was in harm's way, was not in fact harmed by the missed attempt toward a specific person. I think that's a quote from the case.
Yes. And I think that that's consistent with, I mean, maybe not exactly on point, but consistent with DC law as well. And where the convictions have landed. Williams is a good example of that, where even the person in the car of the WICA wasn't a WICA, and they were sitting right next to them. It wound up being a general intent ADW. So yes, it's a true, it's even beyond a stretch in this particular case that Gordon would be found guilty of it. And
I just want to make sure I understand your position. Is it the premise of your answer to the Chief Judge's question that if I'm walking down the street and someone shoots a bullet at me or in my direction and it goes whizzing by my head and just misses me, I'm unharmed?
So you're the person that's being shot at?
Mm-hmm.
Okay. No, I think that depending on different circumstances, then, that person picked you out and there was either a general intent, ADW or a WICA. I'm not sure. It would have to depend upon some other circumstances of whether there was a general intent or a specific intent. But
my question is more abstract. My question is more abstract, which is the following. Do you think someone who is the victim, the complaining witness in an assault that is proven, should be viewed as unharmed or harmed by the assault?
Well, I mean, we have plenty of cases where, people are shot at, someone's not harmed, but it's still considered ADW.
And one way of looking at it, that is that the legislature criminalizes this conduct because it thinks it's harmful to people to be the victim of assault.
Well, I think that a WICA at times can potentially go to unharmed or harmed, depending upon the circumstances, depending upon who was slotted, who was directly in the line of fire, who was sitting next to whom, how far away they are. I don't think it's always a matter of harmed or unharmed, although harmed would help the government.
I guess part of my question is to say harm is kind of an ambiguous term, and to say someone is unharmed, it depends what you mean by harm. And maybe it's clearer to say not physically injured. But I guess so where I start being unsure is if you say that, for example, the complaining witness here was unharmed, or that someone who is the victim of an assault but doesn't suffer physical injury. It's not so obvious to me that person is correctly described as unharmed. For sure, not physically injured. That I get.
Well, we have other laws that cover that as well. I mean, there's intent to frighten assault. The person doesn't have to be harmed for there to be, that there's a statute that covers that. So, no, I'm not claiming that the only argument I'm making is that she was unharmed. I'm just saying that as a factual matter, she was unharmed, and that it would just be a tremendous stretch for the AWICA to go all the way, like in the Maryland case.
Do you think the evidence, I'm with you on that, or your position. Let me ask you this. Do you think the evidence was sufficient here for her to be found guilty of simple assault as a lesser included offense if you don't transfer intent to make it an AWIC?
Well, that wasn't an option for the jury, and nobody asked for the lesser included offense. So, I mean, that would be closer, whether, a simple assault or ADW. I mean, there have been other cases that I've actually litigated where, guys get out of a car and they just shoot toward an apartment building. There's not even, but they're shooting at the apartment building, and they get convicted of 5, 10, 12 ADWs, not even assault with intent to kill, but ADW, the general intent based upon their actions, where they were pointing their guns. I'm not saying it has to be a foreseeability, but there is a foreseeability there. But in this particular case, we don't have any of it. We don't have any of it. And it would certainly be stretching transferred intent. And OICA, if the court did find that there was sufficient evidence in this particular case, and it would go beyond, like I say, I mean, I couldn't find a case where there was a similar situation. The conviction wound up being ADW or assault.
I'm sorry, Ms. Daniels, I didn't mean to cut you off there. But I'm curious why your thoughts on whether the outcome, in your view, should have been different if the government had proceeded under a concurrent intent theory as opposed to transferred intent. Because it seemed like there was a little bit of colloquy, if I understand the record initially, where there was, I forget whether the government requested concurrent intent, and then the trial judge said, no, transferred intent seems to work better here. Or,
what the judge said, there wasn't really an argument about it. What the judge said was, I think I actually have a page number even, 718, 253 to 254. The judge, after some discussion, the judge just said, well, based on our discussion, I'll go on transferred intent, not concurrent intent. And the government didn't say anything. So I don't think the government felt that they could show I mean, again, it's so far removed, a concurrent intent to do something, to Ms. Morris. So, they figured their best shot was the transferred intent. They got it over objection.
Am I right that there was no, or I mean, maybe this is a better question for the government, that they didn't charge AWIC as to John Doe? Is that correct? Do I have that right? Yes? Okay.
Oh, no, I thought you were asking.
Is there any explanation that you can think of for that? Is it just they don't know who the guy is, so that's going to be harder to prove? Is that, was there any discussion about, that confused me a little, and I guess I'll ask the government about it.
Yeah, I mean, I can't really answer for, why the government charged what they did. They charged premeditated murder. That was a not guilty. They charged felony murder. That was a not guilty. They didn't feel it was a part of it.
If they had charged AWIC on John Doe, would you agree or disagree that it was appropriate, that there would have been sufficient evidence to uphold the murder as to Mr. Turner and the AWIC as to John Doe? Another way of asking this question, and the briefs seem to be a little bit indirect about what they're talking about, is there's one line of thinking that because Mr. Turner was hit, that has exhausted the intent, and it can't apply to somebody else. And that's clearly contrary to some DC law. Another way of looking at it is, okay, if you're going to transfer the intent, though, the other person needs to actually be hit. And that, so far as I can tell, is not contrary to DC law, and is consistent with most of the law that I'm seeing from other jurisdictions. So on the hypothetical of if they had charged the AWIC as to John Doe, I think you would be run right up against DC cases, and that would be totally permissible. Do you disagree with that?
Well, even in the reply brief, I specifically said that, we're not saying that a transferred intent gets depleted necessarily by, by it being transferred to one person. It can be more than one person. I did try to clarify that.
If you could clarify, then what's the answer to the hypothetical? Yes, you can, it would be a fine with the AWIC against John Doe and the murder as to Mr. Turner?
Well,
I'm having a real hard time pinning you down, and it's tough to know what your position is.
I'm sorry, I want to understand what you're saying. If the government had charged AWIC on John Doe,
Yep.
and then
And the rest of the facts are
and
the
then
same.
murder on Turner.
Gabriel Turner.
I think that that's closer to what.
I mean, it can't, is this a multi-factor test, or, I don't understand what's close about it either.
I mean, there would be
there
would have to be a transferred intent there. I mean, Turner was obviously an accidental shooting. So in any event, whether you're going to charge AWIC or you're going to charge something else with respect to Doe, you could transfer that intent to Turner, who was between them. I don't think that would cross DC case law, that specifically, because of the close proximity. It was an unintended target. Let me put it that way. When you have the unintended target.
All right, I'm sorry, I know we've taken you over time. I have one more question. Then same facts as this case, only Miss Morris is hit.
I still think that there can't be a transferred intent, whether.
So you are putting no stock in the fact that Miss Morris wasn't hit. Your argument's the same, hit or not?
Yes. Yes, under the circumstances of this case. But you get even further beyond.
Are you sure,
because under
counsel?
circumstances she wasn't. I don't know. In the Maryland case, the person was hit.
Was not hit.
Was not hit. Okay.
No,
I think that.
Maryland court's analysis, they placed a lot of stock on the fact that it was an unintended victim, and there was no harm to that unintended victim. In other words, they weren't shot, they weren't hit.
So in Judge Deal, in your case, then you have an unintended victim, but they are, injured. So, a crime occurred, but I don't believe that that's a transferred intent crime. I think that, that becomes something else. But, we're dealing here with transferred intent. They're not anywhere near it. I mean, it's just a real stretch on the intent part, given all the circumstances.
What's wrong with thinking of it this way? And I'll ask this to the government too. An AWIC versus a murder, is an inchoate version of murder. It's all the other elements, but you didn't actually cause the harm. And the transferred intent doctrine means you're not going to get away from, if you actually caused that harm, but it was against another target, we're going to hold you culpable for that as well, because we're not going to reward people just for having bad aim. That's kind of the rationale that we've articulated. But if you don't even hit the unintended target, then there is no reward for bad aim, because you're still on the hook for the AWIC as to the original target who you were intending to hit. And that's why there's no need for the transfer intent doctrine to come in to prevent the sort of the guy with bad aim gets a boon because even though he hit somebody. That's kind of the rationale of the Maryland Court of Appeals. And the Court of Special Appeals most carefully articulated in Harvey, and the Maryland Court of Appeals has since adopted that as well. And I guess, does that sound right to you? I mean, it sounds like you're taking issue with that.
No, I'm not. I don't mean to confuse the court. I don't feel confused about it, but obviously.
Do you think that that's a rationale this court should specify and adopt? The rationale.
That's what the Maryland court did.
Yeah, and that's what I stated in Harrod and in Harvey, and then those were both Maryland Court of Special Appeals cases, and then the Maryland Court of Appeals subsequently adopted that reasoning.
Well, I think that that's reasonable, and I don't think that it crosses case precedent in this jurisdiction. So that would be my bottom line answer on that.
Okay, so I know this was not the first issue that you had planned to lead off
No.
with. So if you want to move on to some of your other issues, maybe you should.
Yes, if I can, I'll try and do it quickly. So we have Detective Quigley's video, text, and testimony. I just want to bullet why that was other crimes evidence and more prejudicial than probative. We know she's an undercover officer in a Safe Street task force that includes the FBI and Park Police. The testimony was she indicates he's a person of interest by putting out she testifies she puts out a bolo on him. She casts him as, and the others in the hallway as dangerous.
She put out a bolo for him on this case though, right?
No, the drug case.
Okay.
As she's explaining in her testimony, I meet him in an apartment building and I put out this description as literally she said, bolo, be on the lookout. And she said, so later for a description of the person I engaged in conversation with, that's all at transcript 710, 40147.
I'm having some trouble having looked at the body worn camera footage of Detective Quigley, who was undercover, to seeing how this is not just introduced for the stated purpose. It was just to give context to the fact that she had prior contacts with the appellant, and therefore that aided in her identification of the appellant. And, when I see the body worn camera footage, I don't see an other crime. I mean, so help me out here. How do we get from this being more than, hey, we're trying to give you a little context for how this particular detective knew of the appellant?
Right. So I understand what the court is saying, and that's why this is what I'm adding in here was the texts and her testimony describing what's in the video. She says, so I had my first contact, she's describing the video itself. They didn't just play the video. She's actually describing it. And she says, I had my first contact with him. In that first contact, I put out a bolo. Why would you be putting out a bolo if you're just trying to show that you're in contact with someone? So
did you object to that specific bit of testimony?
That is specific in her testimony.
Did you object to that specific bit of testimony?
Well, I mean, defense counsel objected constantly, and in fact,
but defense counsel objected pretty writ large. But when I look at this video, it's heavily redacted. It's about as redacted as, there's barely any words in it, right? And the point that you highlight where there's an exchange, really tough to know what's happening there. And my understanding is you did not object to that particular snippet, and maybe they would have edited that out had you done so.
Well, during her testimony, defense counsel objected again and said, this is turned into a drug trial.
Yeah, but you didn't pinpoint that. So, I think, so here's my point is, I think you're wrong as to the entirety of it. It's clearly it's very probative. And so if you're talking about specific snippets, like a mention of a bolo and a handing of a bag, it seems to me you better have pinpointed those as being particularly troublesome and not just under the umbrella of this thing that you think is troublesome but isn't. So I'm asking, the government says you didn't point out the handing off of the bag as being particularly troublesome. Is that accurate?
Well, I don't know how it got by everybody at the trial level. I saw it on my first viewing. I don't even have that great eyes, that he's actually, that's in our appendix. I stilled it for you, but that's at, 3 minutes and 22 to 26 seconds. So if I saw it, let's assume the jury saw it. So even if, you're saying you don't see anything that looks like drugs are happening, clearly, that plainly, you see it there. There's also her testimony.
Clearly or plainly from my view of the body worn camera footage, and if there wasn't an objection to these particular parts of the video or the officer's testimony, then what your argument is that there was clear error, it was clearly erroneous to admit it, or if there's no objection at trial to these key pieces that you say were highly prejudicial because they showed other crimes, which I'm not sure I see a clear objection like that in the record to the text that said, yeah, how much, or to what you say you saw in the video clearly, that wasn't very clear because it was dark and blurry. What does that mean for us on appeal as we're looking at it? What are you asking?
Well, defense counsel did say, I object to everything having to do with drugs. And when he said that, if you read the entirety of all the objections he made, clearly it's drugs. It can't be anything else but drugs. She puts out, I think that the only very specific thing, like I said, that somehow everybody missed was this packet in his hand, but it was up to the government to sanitize the evidence. It was up to the defense to object. And he did continually object. What we're seeing is, it's clear it has to do with drugs. Why
are you saying the trial judge should have struck it sua sponte without flagging this particular? Because I would say it's not clear that there's drugs or any crime happening from the little snippet of the body worn camera footage that's in the record. It's very dark. It's very fuzzy. It's very difficult to hear. And if the jury is shown that without more context, or if it was so clear that, as you say, everybody should have seen it, then the objection to that specific part of the video and text message needed to be flagged, didn't it?
Well, he's saying that everything that's going on and she's testifying to, it can only be drugs. And I guess I don't understand the neutrality part of, you meet someone in a hallway and you immediately, based on muted conversation, the jury knows it's muted. Okay, they know they can't hear what's going on. But then she testifies, I put out a bolo on him. Why are you putting out a bolo on someone if nothing is going on? That's first of all. Second of all, why does she testify she's worried about her safety? She's worried about if someone has a weapon, if nothing's going on. And in terms of, she also testifies to the text message saying, yeah, how much? How does that help her identify anyone? The thing is that this was, in all my years of doing this, which we're going on almost 4 decades here, I have never seen this type of way of, even if the evidence is probative of identity, the way I've seen it normally is the police officer testifies, I had contact with this individual, I had face-to-face, it was X amount of minutes. The defense didn't even object to a picture of him. And, and then, and they can testify to whatever they want that's probative, because there was probative evidence here. I'm not saying it wasn't. But then the judge says, okay, fine. But if you open the door on cross-examination and challenge her ability to see him or whatever, then they can bring in the videos to show that, because what is it probative of? What is that hallway? What are the videos really probative of? That she saw him, that she was 3 to 4 feet away from him. And I go through that in my reply brief, that the government says it's probative for A, B, C, D reason, but it wasn't necessary. That could have come out in just direct testimony. And if it goes unchallenged, why do you bring in this other evidence and all her other testimony about bolos, about how dangerous these people are, about she's worried about weapons. I mean, it's not just the video, it's her testimony about what's going on in the video, even though she never says, I was buying drugs from him. In fact, in that second video on March 3rd, that was an actual drug sale. I mean, he was, that was part of what he was arrested for later. They did put out an arrest warrant based on that March 3rd second meeting. So, you know, but a jury knows that it's muted. You know, you have to ask why it's not so innocent. I mean, maybe it looks innocent, but, you know, you have a jury looking at this evidence and, you know, why is it muted? Why is she putting out, oh, she put out a bolo on him. Oh, he says, yeah, how much? She's worried, it's dangerous. I have to agree with defense counsel that it can only be drugs. I mean, jury isn't stupid. You know, they're looking at the evidence too. So you can't just buttonhole that video and say, oh, well, the video's, you know, nothing. I mean, if you X out all her testimony about it, then maybe I would agree with you more. But when you add in all her testimony and the texts and all that, you know, I think, and again, the way it's normally done is if you open the door, then this evidence is going to come in. But, you know, the defense was like, hey, let her testify, let her do the still photo. It's just all this other stuff. And if I can move on very briefly to just Detective O'Donnell's testimony, that's issue 4 in our brief. I just want to point out, highlight that, you know, Detective O'Donnell never identified Gordon. He called him the shooter, the individual. He testified he and Detective Quigley viewed the video together. She identified him. The person fleeing was, you know, the shooter. He never, ever, and the government never asked him to identify him. Then on cross-examination, which went beyond direct, and I don't recall if I said that in my brief. If I didn't, I should have. The prosecutor says, it's also correct that Kelby Gordon is the only person standing with the gun behind the seat, right? Objection overruled, that's true. I mean, for that identification testimony come in from a detective, and here's the interesting thing, and then I'll stop if the court wants me to, but the interesting thing about this case is who identifies him in the video? Detective Quigley, based on her prior contacts. It looks like Millie to me. And that's the other thing about it is, you know, Detective O'Donnell calls her and says, hey, you know, I got this guy that looks like whatever. And then suddenly out of the blue, she goes, oh, that sounds like Millie. I mean, unless he was engaged in other crimes and she, you know, he wasn't a thug or otherwise. I mean, if someone described my neighbor, someone that looks like my neighbor, I wouldn't say, oh, that must have been my neighbor. So there's that aspect of it too, that, you know, Quigley immediately thinks of him because, you know, based on her prior contacts. But here's the thing. So Quigley identifies him, but really, who knows Gordon best of all the witnesses? Malloy is his girlfriend, Culver, who knows him from the neighborhood for a long time. The interesting thing, and I think that this did give the jury pause. We know that they did deadlock. The video of the shooting isn't clear, okay? The government never asked Malloy or Culver if that was Gordon in the video. And I think that's a big because, you know, you're relying on Quigley, then the government's like, oh, I only have Quigley. Let me try this, get this in for the last thing that the jury hears of a defense witness, which we argue invaded the province of the jury. But it is very interesting that Malloy, especially Malloy, I mean, she identified a photo of him, but she never identified him as the shooter in the video. So if the court would like me to speak about the circumstantial evidence instruction, or if the court would like me to stop.
I had one other brief question on the sentencing. And it seems that the trial court's oral sentence was a bit unclear on the mandatory minimum associated with the firearms violation and the while armed pieces of the sentence. Did you want to say anything about that?
Well, an oral sentence takes precedence over a written one. I mean, that's pretty much, that's case precedent. And, I would say that it wasn't exactly unclear because he said total 60 months. So he didn't just say 60-month mandatory minimum. He said total 60 months. So
For each firearms violation and while armed pieces for a total of 120 months, or there seems to be some ambiguity there, or lack of clarity.
Yeah. So he refers to the while armed of the greater charge, and then the court, it kind of in one breath says, well, we got the while armed from the greater charges. We have the the firearm offense, and then he says total of 60 months. So, to my mind, the court considered both and said total of 60 months. So
it's like that sentence just in isolation is somewhat ambiguous because it goes, there's a comma and then says total of 60 months of mandatory minimum time. And the question would be, and who knows how much weight you want to put on the punctuation of a transcript, but whether the total of 60 months refers to the second half of what precedes it, the while armed pieces of the sentence. So for the while armed pieces, it's a total of 60, or whether it refers to both. There's a mandatory minimum associated with the firearms and the total is both of them added together. So that seems a little unclear, but what makes it even unclearer to me is the preceding couple sentences where the judge imposes two 60 months mandatory minimum sentences of 60 months on two different counts that are run consecutive. And so if you're saying I'm giving you 60 months mandatory on count A, this is simpler than what we had actually, and 60 months mandatory on count B, and they're consecutive. Those sentences are the sentences on those counts are consecutive. Then that would seem to point towards 120, whereas the latter sentence, even if it does point to a degree towards 60 overall, seems to be at most somewhat ambiguous.
I don't have the transcript right in front of me, but my best memory is that the only time that he spoke to a mandatory minimum was the part where he says total. I don't know that there was a separate part where they say, I'm imposing a mandatory minimum, I'm imposing a mandatory minimum, and now the total is 60.
You're quite right. No, you're right. But the problem is if I impose a sentence on A and on B, and I say those are consecutive, and then later I say, there are mandatory minimums on both A and B, then that seems to, I don't know that you could run counts consecutive, but make the mandatory part of them concurrent. So it seems to imply that they were going to be running the mandatory minimum, the two different mandatory minimum sentences that are referred to in that one sentence that discusses mandatory minimums, they're put on consecutive counts. So it would seem you'd have to add them together rather than running them concurrent. That's the ambiguity I see. But you're right that when the judge imposed the sentence on the counts, count by count, the judge did not refer to mandatory minimums, just imposed a sentence and then said it was and then said that the sentences were consecutive.
Right. I mean, had the judge said mandatory minimum, and then just added wrong, that would be a different scenario. So, does the court have any other questions for me about anything else? I would just say with the circumstantial evidence instruction that I don't think that there's, that the court has dealt with this before. The government was able to point to some other jurisdictions that have embraced this cupcake thing. But I would really say that in this jurisdiction that the court should not embrace it. It doesn't appear to be a neutral instruction like the Red Book instruction for various reasons. One, if I just say real quickly, is that it's premised on bad behavior. It lends itself to many other possibilities that snow, rain, and other examples don't. The only possibility is not just that the kid ate it. A lot of things could have happened to that cupcake. And I say that in brief. I go through that in the brief. So, you know, I just think it would.
Can you just tell me why you think this implicates wrongdoing? It talks about a child who eating their birthday cake, their birthday cupcake. If they tell them, it's direct evidence. If you find them with it, that's circumstance with frosting on their face and crumbs leading to them. At what point do they say that the child, without permission and in defiance of his parents, eats the cupcake? I mean, nothing about this is perfectly neutral. This is they're eating their cupcake, and it's in fact identified as their cupcake. I mean, taken on its terms, I don't see how this is anything but neutral.
Because the instruction itself said, okay, that it was a missing cupcake, not just that there's a, you know, I mean, it implies that that it was expected to be there and now it's missing versus I put a cupcake on the table for my child for his birthday. It was his birthday cupcake. And
it is described as their birthday cupcake, and the rest seems like quite a stretch to me, counsel, to you know, infer some nefarious polluting of the jury through that example. But I'll leave it at that.
All right, Mr. Daniels.
You know, but when you add in the government, the second part of our argument is not only the instruction, and I won't go into all of it, but the closing arguments that track it. I mean, you go from cupcake crumbs to stones. It was the government's suggestion.
Well, there's no question they think that your client did something wrong. That's doesn't make the example that they're tracking loaded. That's, you know, I won't keep going back and forth with you on it though.
All right, Ms. Daniels, you can reserve a couple minutes for rebuttal and we'll hear from the government now. Thank you.
Thank you, Your Honors. May it please the court for the United States, David Goodhand. I'll address my opponent's issues in order as they were presented by both my opponents.
Can I just jump in with you on this WICA and whether or not there was sufficient intent? And, you know, we've had some of these discussions about what intent is needed in other contexts. And is it the intent to do the act? In other words, intent to fire a gun, to shoot a gun, or is it the intent to assault or act toward a specific person? And if it's merely just the intent to do the act, why do we even need a transferred intent doctrine at all?
As I understand the doctrine, it's the intent to kill here, speaking specifically to this case, that is transferred. So here we had John Doe. The defendant was shooting at John Doe. The government believes it proved sufficiently that there was an intent to kill John Doe. John Doe wasn't harmed. Two other people, however, were. Obviously, the decedent, Mr. Turner, and then Ms. Morris, who was in the apartment directly across from the cut where the shooting occurred. And so, and if you look at the
harm, let's talk about the harm to Ms. Morris.
Sure. You know, and before I go too far down this road, I want to, you know, we have suggested that this was not properly raised in my opponent's brief. My opponent raised a number of claims. And in particular, if you look at page 35 of her brief, she says the conviction should be vacated under either theory. And she articulated two theories. One was intent can be extinguished if you miss one victim. And two, it had to do with second-degree murder. My point being that, and I would add, she has not cited any of the Maryland cases that have been bandied about here. I'm happy to address any questions. I'm going to, but we don't think this issue is properly raised. This is a very complex issue, and I will move on. But that's something we raised in our brief, and we don't think it was properly raised here. But in terms of harm, I look at the jury instructions with a WICWA, and these were outlined the July 19th per transcript at 422. You know, there is a defendant acts with force to either injure or attempt to injure. The defendant acted on purpose. Defendant had the ability to injure Ms. Morris, and the defendant intended to kill Ms. Morris. Now, I do not see in there any requirement that there actually be physical injury.
That's funny because you started off by saying that John Doe wasn't harmed. You want to walk that back?
Well, yes, you're right. I do want to walk that back. When I said harm in that sense, I meant he wasn't physically injured.
And why is it that the government didn't charge? Am I right that the government didn't charge Awick as to John Doe? And can you just maybe explain, if you have any explanation as to why that would be?
I don't have an explanation. And again, I didn't look into this in advance of oral argument or in writing the brief. Instead,
because you wouldn't have to rely on a transferred intent theory. There you'd have the intent to shoot and kill John Doe. And your only question would be whether or not the intent was exhausted by the murder of Mr. Turner. And the answer to that question strikes me to be quite straightforward, that the answer is no under our case law. The separate question of whether or not transferred intent, now you read the AWIPO instruction, but let's put that aside because it's really a question of whether or not the transferred intent doctrine applies where harm does not befall the unintended victim. And on that question, it doesn't strike me that any of our cases speak to it. Williams doesn't. The other case you cite is ZDT INRE. It's from 1990. I forget what it was called. Both involved unintended victims who in fact got injured. One was 2 gunshots to brothers, I believe. The other one was some correctional officers who got punched in a fray. Nothing where they weren't actually hurt. And now, so that's not a topic we've covered. And other jurisdictions seem to say transferred intent doesn't apply there. Do you want to talk about why, in theory, you think it should?
Sure. And again, with the caveat that I do not believe my opponent raised this issue, and I would be happy to supplement with anything if the court would order. But this is a very complicated issue. I did not go outside the jury.
Just so I understand your argument, you don't think they raised it in the trial court, or you don't think they adequately made it in this appeal, or both?
The latter. It was definitely raised in the trial, right, for sure. But here's my understanding of and why I do not think you need physical injury. First of all, to be clear, Ms. Morris testified that she was, quote, terrified, this is at 7-11 transcript 496, by the bullet entering her bedroom window and lodging in the wall opposite. That, I would suggest, is a harm. She was terrified by a bullet entering her apartment as she was sleeping.
Can I tell you, if I lived in that building, no matter where I lived in that building, I think I'd be pretty terrified. Do you think, if there's 50 people in that building, 50 AWICs?
I think, again, this is a difficult issue. What is the stopping point for this doctrine?
What is the starting point for the doctrine, I guess? Because I understand the starting point for the doctrine to be, we don't want to excuse criminal behavior just because someone has bad aim and they intended to shoot A, but shoot and harm or shoot and kill B. And here we don't have that. And that's how we, as I understand, I've always framed why we need a transferred intent doctrine. Here, we typically think of it as shooting, injuring, harming with a physical injury, and we want to punish that kind of behavior. But here, it seems like we've gone a couple steps beyond that, where it's an unintended person and it's no physical harm here. A miss, in other words, a miss, not a hit that just hit the wrong person.
Sure. I disagree that the outer marker or the necessary requirement has to be physical harm. And there's not much in this court's jurisdiction about this issue, but I would direct the court.
Are you familiar with the Maryland cases?
I am not, Your Honor.
Okay.
Again, these were not cited in my opponent's brief, but I will direct the court's attention to O'Connor, which is sort of the seminal decision on transferred intent in this jurisdiction. And if you look at O'Connor and they explain why do we have this doctrine, and in particular, I would direct the court's attention to 399 A. 2nd and 24. And the court says it is every man's business to foresee what wrong or mischief may happen from that which he does with an ill intention. And I think the court is getting at there is this notion that if you do not get a pass, if you go down the road of acting with the requisite intent to kill, here is the requisite intent, and harms thereafter unfold as happened here, both with Mr. Turner, obviously, and with Ms. Morris, who was terrified in her apartment, then you are assumed to have foreseen that wrong or mischief that happened.
The next sentence in O'Connor is not going to help you, counsel. I mean, the illustration it provides after "is every man's business to foresee the wrong or mischief that will occur." He said the illustration of that is if a man of malice shoots an arrow at another with intent to kill him, and a person to whom he bore no malice is killed by it, this shall be murder. That aligns with Chief Judge Blackburn Rigsby's understanding of why we have a transferred intent doctrine. But to say, not only do you need to foresee sort of the actual harms, and I appreciate the point that harm is a malleable concept. So let's just say physical injuries, but also anybody who might be put in fear of it, that might encompass the whole neighborhood.
I do not disagree with that. However, here I would suggest is a breaking point. If you want an outer marker that precludes the possibility of a 300-page indictment, we can glean it, I would suggest, from Lloyd. Lloyd, of course, reserved this question. Lloyd said, here we don't decide what to do when the harm is entirely unforeseeable, is how they phrased it. Because, Lloyd said, the evidence indicates that the defendant knew or should have known of the presence of the other victims. And I would suggest that is a breaking point to preclude sort of 300 victims in an apartment building. And here we should have known, to the extent that we had six bullets fired down an alley. And at the end of that alley, as the testimony indicated, and as the photographs indicate, at the end of that alley, you had an apartment building. And in that second floor apartment facing Martin Luther King Avenue and facing the cut, you had Ms. Morris's bedroom window and her living room window. A bullet went through the living room window, a bullet went through the bedroom window. This was, the testimony also established, just 100 to 150 yards from the shooting.
Yeah, I guess I don't see how that's a limiting principle, counsel. I mean, he should be able to foresee that many people live in that apartment building, each of whom might be put in fear of having their apartment building shot.
I think the limiting principle there in the should have known category, if we look at Lloyd's language, and again, that's just dicta for sure, but if you look at the should have known language, we wouldn't probably be making this argument if you had an apartment on the other side of the building with windows that weren't facing the alley 100 yards away from the shooting, where 6 bullets were unleashed in daytime to an apartment building. So
I wonder whether another possible set of limiting principles, I'm not sure they'll end up helping you, but I want to ask about some other possible limiting principles rooted in merger considerations. And so I take as a given that if there are a bunch of people standing on a street corner and a defendant shoots at them generally, and maybe you don't even know who the defendant was aiming at or whether the defendant was aiming at any particular one of them, that ends up being, assuming none of them are hit for a moment, that ends up being one assault with intent to kill. Do you agree with that premise, or are you not sure?
I agree with that premise, yes.
And what happens if one of them gets hit and none of the others do? Is that somehow then become more than one, or is that still one?
I think it becomes more than one. And again, I think this is what Lloyd was suggesting. If your hypothetical is, if I understand it correctly, is that there.
But this is not again, to be clear, this is not a transferred intent issue. This is a double jeopardy, multiple punishment merger question, not a transferred intent question.
I'm sorry. I apologize, Your Honor.
I don't think Lloyd said anything about it directly.
No, Lloyd certainly did not speak to merger. I think I understand I think I understand Nixon, and you know, again, this wasn't argued. I haven't thought about this to stand for the proposition that that would merge.
There would be just one.
Yeah, I think I understand Nixon to stand for that proposition.
And when one could wonder whether merger principles would end up limiting the number of people in some of these, and one could wonder whether they also would require merger of the uninjured person and the injured person in something like this. I just don't know. So, let me ask you one other question. So that's just an area of uncertainty, for me at least. I thought you started your argument on this topic by suggesting that you had argued in your brief that this point or some related points had not been properly raised on appeal. Is that
Yes.
Where can you show me where?
Yeah,
you,
sure, absolutely. This is footnote 32. Appellant only expressly argues his AWICWA should be vacated pursuant to either of two theories, and we address those both in the text. And instead, my opponent described the procedural history below on the prior page of her brief at 34, just describing the arguments at the sufficiency of the evidence stage.
Well, I mean, I'm familiar with that footnote. I just don't see where it says. I mean, it does say there's only certain express arguments and then discusses some other things, but I didn't see any point where it made any kind of explicit, here's an issue that's not in front of you, don't decide it, point.
No, you're right. It certainly wasn't expressly stated. Certainly seems to be the import of that argument. It's also why it's devoted to a footnote. You know, my opponent raised numerous arguments. I have limited space.
Fair enough,
This is
but
very
that's not focused on the question of harm or lack thereof in the sense of physical injury. This is focused on the foreseeability point of it.
Yes, absolutely.
So this is focused actually on a different line of thinking than the one that we're focused on to a degree now about physical injury or lack thereof.
Yes, which is another complication. Do you need actual physical injury? Do you need actual foreseeability? On that latter point, I would direct the court's attention to the fact that Lloyd at least cites the Melton case from Massachusetts. And again, Lloyd did not adopt entirely Melton, but Lloyd cited Melton approvingly, and Melton is quoted as the intent, quote, encompasses completely unintended victims, open paren, including victims of whom the defendant was unaware, who happened to suffer along with the intended victim. That's Lloyd at 806 A second 1250, quoting Melton. So again, at least that's if we're digging around in dicta and hints from this court's decisions, that certainly seems to suggest that this court was somewhat comfortable with the notion of an completely unaware victim out there possibly being on the back end of the transferred intent doctrine. But again, we don't have a completely unaware scenario here. We have a should have known scenario that Lloyd indicated precluded the necessity for deciding this issue in Lloyd.
I don't want to belabor the point, but I'm actually think if they're completely unaware, that's totally fine. Transfer intent applies so long as they're actually harmed physically. And that's what I would think is the outer boundary of the doctrine. It's foreseeability. It just doesn't come into play in the way I've been trying to ask my questions, and I keep hearing it come into play in the answers. And I'll just to make clear, that's not my concern, at least.
I understand, Your Honor, and I apologize if I haven't been addressing your questions.
No. You've done fine. I just wanted to make sure I didn't leave. I agree with you to the extent that sort of the theory under which appellant is taking issue with is the transferred intent doctrine is not so finely tuned, and it seems to be a moving target a little bit, both in the brief and at argument. So I don't fault you for not answering the questions. To the extent I haven't been clear, I just wanted to make clear that I was more focused on the harm element and whether or not transferred applies absent some physical harm. That's where my concerns have been. That's all.
I understand.
Okay.
And I would add this. I do know for a fact a lot of ink has been spilled on these various questions. This is a very complex area of the law. And, if this had been teed up appropriately, then of course I would have addressed it. I've made my point on that.
I'm still not quite clear on why you think it wasn't teed up appropriately before.
Sure. I can direct your honor to chapter and verse on that, if you will. It's page 35 of my opponent's brief, and in particular, the final sentence of the argument addressing the AWICWA under either under either theory appellant puts forth here, his conviction must be vacated. I took opponent at his word, and the two theories that were presented above, one was you can extinguish intent if you if you applied it to simply one unintended victim. I addressed that. The second related to the conviction for second-degree murder, which is it can be based on either conscious disregard or an intent, and I addressed that in the text. So
I would just say, though, if you look at page 35, there is the reference to, doesn't support a WICWA of an unintended, unharmed victim who was merely put in fear. So there seemed to have been, and the concept of this victim or this complaining witness being unharmed also is mentioned in the reply brief.
Sure.
To the extent the point is it isn't front and center or fully developed, I agree, but I think in fairness, it needs to be acknowledged that the concept of lack of injury was referred to both in the opening brief, in the discussion, the legal discussion, and in the reply brief.
It's entirely fair, Your Honor.
So are you suggesting, Mr. Goodhand, if we wanted to opine one way or the other on this transferred intent issue, that we'd have to require supplemental briefing, that we don't have sufficient basis to do so on the record and arguments before us now?
I'm suggesting that that would be one possibility. Obviously, it's within this court's discretion to decide the issue. I certainly would like the opportunity to weigh in on an issue that such as this, which is highly complex. But of course, this court can do its own research if this court concludes that it was adequately raised. But entirely this court's call.
You would prefer it? If we were to address it, you would like the opportunity for supplemental briefing?
I would. I think it's a complicated issue. I think a lot of ink has been spilled on this in various cases. Lefebvre, I know, talks about it in some length. And I think, if this is something the court wants to address, then it's always good to get both sides of the argument. Your Honor, I can touch briefly on the other issues raised by my opponent. As to the suggestion that the defendant, the trial court abused discretion relating to the testimony of Detective Quigley and the videos, the court, sort of acting at the pinnacle of discretion here, appropriately considered the incredibly probative value of the testimony and the videos, weighed that against the danger of unfair prejudice, and correctly concluded that the incredibly probative evidence, once sanitized, once redacted, once muted, could come in as it did.
And how are the texts incredibly probative?
Yeah, Your Honor, the text had probative value as the government referred to them in closing. And in particular, I would direct the court's attention to the July 18th closing argument at 301-02. We used the text to connect the defendant with the two phones that were also linked to the defendant. So in particular, Nadia Malloy, the girlfriend, identified the 016 and 4960 phones as ones that the defendant used. Those were also the two phones that the defendant used in the course of his interactions with Detective Quigley. And the text, again, if you look at the record, you see that we held up the screenshots of her phone, and it showed the phone number, and it did indeed show the text. But then when you get to the closing argument, you see that we highlighted the fact that these were messages coming from the phones that were linked with the defendant via Nadia Malloy. And more particularly, the 0196 number had particular relevance because that was the one that the defendant used to communicate with Boohead.
If I remember right, on the videos, you have the defendant giving his phone number to
Right.
Detective Quigley. Is that? And so, I mean, how much I take it you would agree that maybe it would have been better to redact that. Was that not highlighted? But did defense counsel not pinpoint that as being like particularly suggestive of narcotics, street dealing, and serving no purpose other than prejudice?
It was not highlighted by defense counsel. And, you know, of course, the trial court exhorted the defendant to identify anything of that ilk. And again, if you look at the closing argument, I think this is a critical point. It's July 18th at 3:01:02. We only highlighted two texts there. The first one was, "This is Millie, hit my phone." The second one was, "You good, Terry? I see you ain't hit my phone." So we don't mention the text that my opponent has focused on here, the sort of how much text. It might have been a little bit of icing on the cake that was perhaps unnecessary. But again, this gets back to, you know, when you're in a discretionary world, there are shades of decision making, and this court, you know, looked at both the videos, looked at them twice. The record indicates, and listened to the testimony of Detective Quigley, and was quite sensitive to other crimes. You know, as I indicated in my brief, in fact, the trial court jumped in and interjected at a later point in the trial when Nadia Malloy was asked by defense counsel, well, had he ever mentioned crimes before? And the trial court jumped in and said to counsel, you don't want to ask that question. There was another instance where the government tried to argue that a domestic violence incident should come in because the door was opened in their cross-examination of Nadia Malloy. The court said no. So, you know, this is a judge who is, I would suggest, highly sensitive to the risks of drawing untoward propensity inferences, and appropriately ruled here that the incredibly probative evidence was not substantially outweighed by the risk of unfair prejudice.
How much quote? You know, what other inference could the jury have drawn other than that this an illicit drug transaction?
You know, actually, that it's unclear what that's referring to. It came in the course of a description of Detective Quigley moving to the building. Perhaps it could be a reference to distance, how much longer. I don't think it's a necessary implication, and I think that's perhaps why defense counsel didn't mention it or highlight it or even object to it. But again, you know, it's very, very, very tiny piece of the puzzle here of the incredibly probative evidence. And again, wasn't even mentioned in the closing argument by the government. So I don't think there's a necessary implication that can be drawn from it, number one. And number two, it certainly wasn't highlighted in the slightest. It was just a blip in the detective's testimony, if you will.
Can I move you on, unless there are any other questions on this topic? I wanted to get your take on the clarity of the trial court's oral sentencing. Do you think it's clear that the trial court intended to impose a mandatory 120-month minimum?
I do. If I understand this court's case law, and I may be wrong, but if I understand the Gray case, for example, and that's 585 A second at 166, you only beckon to the oral transcript of a sentencing if there's if the oral transcript has clarity that somehow trumps the written JNC. And here, what we have, I would suggest, is a written JNC that is clear, 120 months mandatory minimum, that, and at best, I would suggest an ambiguous oral statement from the court relating to the necessary mandatory minimum. You know, again, I concede it's not entirely clear, but I read the court's oral statement at the sentencing transcript at page 18, I think it is, as applying to the two PFC-Vs that were ordered consecutive. There was a PFC associated with the murder, the second degree murder. There was also PFC associated with the AWICWA, and those both have mandatory minimums of 5 years. I read the written judgment as applying 120 months to the two consecutive PFC-Vs that were stacked by the court relating to those two substantive offenses.
Counsel,
Well, if
I
we
make sure-
vacate the WICWA conviction, would you concede that the mandatory minimum sentence needs to be reduced as well?
I think it does not. I do not think there's a mandatory minimum associated with a WICWA. I think it only applies to first or second degree, the while armed provision. I think that only applies to first or second degree murder. So if that PFCB goes away, then I think that might be.
Counsel, I want to make sure I understand what you said about Gray, because it sounded, well, let me ask you a hypothetical. If the written judgment and commitment seems very clear in what it says, and a defendant says on appeal, there's a problem. If you go to oral pronouncement of sentence, the judge said something different. Are you saying that you couldn't look to oral sentencing unless the written sentence was unambiguous? Because I thought it was that the law was different, and that if the defendant was right, that there are two, one seems unambiguously to say A and one seems unambiguously to say B, that oral pronouncement of sentence would govern in that circumstance. Do you think were you suggesting that your reading of Gray is something different from that?
No, I thought I understood Gray to stand for the proposition if the oral is ambiguous, then the written sentence, the written JNC would if the oral sentence is ambiguous and the written sentence would predominate.
Can I ask you just quickly, can you explain why you think it was an error to overrule the defense objection to the identification testimony of Detective O'Donnell? Yeah, I was unsure whether he was a detective. I think he's Detective O'Donnell.
Yeah, he was Detective O'Donnell. I mean, I think it was an error or an abuse of discretion, because I think if you look at the question that the prosecutor posed, it was somewhat inartful. I think it had a couple premises in it. And I think, frankly, if I had to guess, it's hard to get into a trial court's mind, but the court understood, as I think the jury properly understood, that the question was really designed to get at where was the gunman standing, not was the gunman Kelby Gordon. And so I think in overruling the objection, I think the court probably had the same reaction that the jury did, which was this was not Detective O'Donnell identifying Kelby Gordon as a shooter.
Well, I mean, it literally is. And for a judge to say, I'm going to overrule an objection because although the testimony as it's literally being elicited is not admissible, I'm going to be confident that the jury in its context will not read it literally, seems like a difficult doctrine of law.
I don't disagree that if you look at the Q&A, that one reading of it is for certain that there was an agreement that it was Kelby Gordon as a shooter. I just think, the objection, there was no.
Can I ask you, do you concede that to the extent that evidence is understood to be Detective O'Donnell identifying, saying the person in that video standing behind the decedent is Mr. Gordon, if that's how we understand the evidence, or that's how we think the jury would have, do you agree that it would be inadmissible so understood?
I'm not, the reason I hesitate is this, Your Honor, we're in the defense case. The judge has already ruled on a motion for judgment of acquittal and concluded that the government had adduced sufficient evidence demonstrating that Kelby Gordon was in fact a shooter. That's my hesitation.
I don't see why that's relevant. So maybe you can explain why that makes you hesitate. But if it seems like the gist of your point is, although this witness wasn't competent to answer the question, the jury might have had other evidence that would have allowed the jury to think that the witness was right when the witness was testifying to something that the witness wasn't competent to testify to. I'm not sure I see that line of thinking.
I guess the line of thinking is the jury, the witness became competent as to that position based on the other evidence that the witness had himself seen.
I'm sorry, you mean because the witness was sitting through the trial?
And also had done the investigation, yes.
I'm sorry, was the witness sitting through the trial? Like it was in the
Your Honor, I don't know the answer to that question,
right.
But he was the lead investigator. No matter what, though, I mean, this was a fleeting reference. It was, I think the context suggests it was inadvertent. on the part of the prosecutor, the compound premise.
Yeah, I mean, I suppose as part of your answer, the objection might have been to something else, and it just wasn't clear because you said, is it correct that Kelby Gordon is the only person with a gun standing behind the decedent? The objection, I bet the trial court probably thought, well, you can't speculate if there's other people that are out of frame or something like that. I mean, that's
a possibility.
Because a little uncareful of the trial judge to permit.
No, I understand your honor. I just think that because the defense counsel didn't identify the nature of the objection, given the sort of inartful phrasing of the question, it's susceptible to a number of readings. But obviously the government never mentioned this Detective O'Donnell testimony in closing, and instead focused on the voluminous other evidence indicating that Kelby Gordon was in fact the shooter, the two confessions, one from the girlfriend, one from Mr. Culver, Detective Quigley's identification, and the cell phone records indicating his phone was in the area at exactly the time of the shooting. So could you just clarify the record for me? When you say other identifications, which witnesses, if any, identified outside of Detective Quigley, identified Mr. Gordon from the video as that's definitely him? That was only, Your Honor, that was only Detective Quigley. Okay, just wanted to make sure. Yeah, no, I was maybe somewhat vague. When I say confessions as identity evidence, I mean, Nadia Malloy identified the defendant as telling her that he shot the decedent, similarly with Mr. Culver. And then that's corroborated, of course, by the cell phone tower analysis, which puts his phone there. So, with respect to this single inadvertent reference, it's a stretch, significant stretch, I would suggest, to say this somehow usurped the jury's role. They were instructed, you are the sole arbiters of all the facts. And defense counsel in his closing said, you are the ones that have to look at that video and figure out if that's Kelby Gordon. So I think this was just, if you will, a blip in the larger scheme of a 2-week trial. I'm significantly over my time here. I will pause if there's any questions, but if not, we would ask that the court affirm the judgment and conviction below. Thank you.
All right, thank you. Ms. Daniels, you have a minute or two for rebuttal.
Yes, I'm going to work my way backwards for the moment. Detective O'Donnell, that area. I don't think it was an accident. The prosecutor could have asked the question and left out the name. It could have said, isn't it also correct that that there's only one person standing with a gun behind the decedent? I don't think that it was an accident. The prosecutor probably knew that they got away with something and didn't want to highlight it in closing argument. But what the government did highlight in closing argument was that police officers are trained to ID people. They're not the usual eyewitness, casual observer, and they're given more credence because they're trained to ID people for a living. And, now you have, to me, that I can't read that any other way other than him identifying what the jury is supposed to ultimately find. I mean, the real question in this case is, who's the guy behind Turner? And, Detective O'Donnell says it's Gordon we always say the juries are intelligent. They couldn't have missed that he never identified him at all during the
defense counsel didn't ask for an instruction saying, instruct the jury that is an incompetent identification, right? Didn't ask for a mistrial based on that. Didn't seek any remedy other than saying objection without providing a basis for that objection. I mean, is that all accurate?
That is true. That it said objection, the court said overruled, and the witness answered. I mean, you're just adding to my 23 and 10 things. But speaking of which, I'll move on to the other that the government saying that an issue wasn't fairly raised. I could have been more articulate, to be honest. It was hard for me to finely tune my argument because there was no case law on the unharmed victim. And so that's why my effort to do that, and I did embrace trial counsel's argument, I think I specifically said that, but was to distinguish Williams, where you have someone that was injured, now you have someone that's not injured. So, and there was only ADW in that, and now you have someone who wasn't injured. So how do you get to AWICA? So I don't think that, I was surprised that the government said that. Certainly had they said that in their brief, I would have addressed it and not, having to address it now. I'd also say that I don't think that there's a need for supplemental briefing on the issue because, the case law is like the chief judge said, we haven't spoken about it. So, we're going to be talking about a Maryland case. And like I say, nothing goes this way. The Maryland case doesn't cross any DC cases. So I don't see a need for supplemental briefing.
There are some other jurisdictions, like New Mexico is one that goes the other direction, though. There are jurisdictions that go the other way, just to be clear.
Okay, but if we are going to do supplemental briefing, then I'd appreciate it if the judge would give me the Maryland citations again. I didn't happen to write them down when you mentioned it. And the only other,
if you decide to do supplemental briefings, we can include the Maryland citations as well as New Mexico, if that would be helpful. But we haven't crossed that bridge.
I can give you one now, I can give you two of the New Mexico and Maryland one, just in case you're curious to look. And I don't have the Atlantic Second reporter, but I have 111 Maryland App 401. That's Harvey. I know the chief referenced Herritt. I don't have that one. But I do have a State v. Gillette out of New Mexico, 699 P2D 626, which seems to come out the other way. So if
I have the Herritt is 65 Maryland App 128 and 499. It could also be found at 499 Atlantic Second 959. It's a 1985 case.
I just want to end with the Detective Quigley that the government addressed. I mean, the standard is, was it other crimes? Was it more probative than prejudicial? And I think it was a pretty easy jump for the jury to know. I mean, even if it wasn't drugs specifically, that it has to do with crime. This is someone who's part of a task force. She's having contact with him. She puts out a bolo on the guy. It's just, smacks of it that, Gordon's a thug. What else? She associates him with the people she's investigating. I mean, that's. And then I'm sorry.
I was just encouraging you to wind down.
Okay.
Please.
My final sentence on that was going to be that you do have him holding a packet of drugs, in the video, regardless of the fact that no one caught it below. To say that there's no evidence of drugs, it would just not be true. So in the end of it all, I just say that, Mr. Gordon said one thing at sentencing, one thing only. He said, I don't feel I had a fair trial. I think this court should agree with him, vacate his convictions based on singular cumulative errors, but for the AWICA conviction on grounds of insufficient evidence. And thank you for your time.
All right. Thank you, Ms. Daniels and Mr. Goodhand, for your briefs and arguments today. And we will take the case under advisement.
Thank you.
Thank you, Your Honor.
And you're free to leave our virtual courtroom at this time. All right, good afternoon, counsel. I see Ms. Gabriel. Mr. Ivey, are you able to hear us?
I can, and I now have cut on my video. Are you able to hear me?
Yes. Okay. Good afternoon to both of you. This is our third and final case for oral argument today in the matter of the case of Urbano Vasquez versus United States. And counsel, are you ready to proceed?
Yes, Your Honor. Thank you, Your Honor, and may it please the court. At a pretrial hearing on the appellant's motion to exclude expert testimony,
Mr. Ivey, I would just ask, just for the record, we can obviously see your name on the video. If you could just state your name for the record and let us know if you want to reserve any time for rebuttal.
Yes, ma'am. My name's Glenn Ivey, and I represent the appellant, Urbano Vasquez. I'd like to reserve 3 minutes of my 15 for rebuttal.
Thank you.
Thank you, Your Honor. So the trial court granted, were essentially based on the appellant's motion, decided to expressly preclude the government expert from offering any testimony regarding the complainant's or the reporter's credibility. But the expert, Dr. Wolf, violated the trial court's restrictions by testifying that she'd only seen children make false allegations of sexual abuse when there's either a child custody dispute or if the child has a serious psychiatric problem.
Now, I don't believe the expert is ordered to do anything by the court. I suspect what the court ordered was the government is not allowed to elicit any testimony like that. As far as I can tell, the government obliged and followed that order. If the defense wants to give up its ruling by eliciting testimony that you were now complaining about, I don't see that as being on the expert. I see that as being on the defense. Don't elicit it. And it seems like you even, the defense counsel even prefaced, this is probably a bad idea to let you run with this question, but here goes. And then engaged in a long colloquy about whether or not they think children lie and why they might lie. And that's what you're complaining about, are things that elicited by the defense. Why isn't all of this under the invited error doctrine?
Well, 2 quick points on that front, Your Honor, and thank you for the question. One is the court's ruling didn't limit the testimony based on who was eliciting the question or the testimony or not. Court said, so just to be clear, she's not going to be offering any type of opinion as to whether or not complainant 1, complainant 2, or reporter are credible. And she asked the same question with respect to any kind of testimony that would go to bolstering the testimony of complainant 1, 2, or the reporter. She didn't limit this to the government or you know.
I mean, a fair reading of it is the government can only speak to, this is a question to the government. The government can only speak to what they're going to put their expert on for. You know, if the defense wants to elicit things totally different, the government really can't make any representation or give the court any assurances of what the defense might decide to do.
Well, this was based on a defense motion, so clearly I would suggest this isn't the kind of testimony that the defense would have wanted. And to get to the second point, I don't think the record shows that they elicited this statement at all. To the contrary, I would say. Clearly, defense counsel was asking the questions at the time, but these were volunteered statements that were made by the defense expert. You know, for example, her statement that it's very unusual for any child to want all of the terrible consequences to happen wasn't connected to any kind of question that the defense counsel asked.
Why is it not connected? The general question is, like, what are the factors that, you know, cause children to lie? It just seems like for better or worse, the defense attorney decided, expert, run with this, roll with this, tell us your thoughts about when children do or don't lie. That seems to be what was probably the answers weren't substantively what the defense attorney was quite hoping for, but I don't see them as volunteered in the sense of unrelated to the question that the defense counsel was posing.
Well, I would say they were unrelated in the sense that they were unresponsive to the questions that defense counsel asked. So, for example, the one I just read, the question that was asked was, what about the case of a Pennsylvania teacher, Michael Gallagher? And what he was trying to get at was there's a false allegation that was made in that case, and that these are not child custody cases, which is a quote from the question. She said it's very unusual for any child to want all of the terrible consequences to happen. Hard to see how that's responsive to the question that defense counsel posed.
What about some of the hypothetical questions? It seems like when defense counsel posed a series of hypothetical questions on this issue, those seem to invite open-ended narrative responses from the expert witness. And when you do that, then aren't you sort of stuck with the consequences of the open-ended response from the expert expounding on the hypothetical that was directed at them?
Well, two things on that front. One is that I don't think he asked any hypothetical questions here. He asked about the specific case, about the Pennsylvania teacher, and he asked about, in the other instance, what might happen. How do you account for scenarios where children without symptoms make false allegations? And
a little bit.
Okay. And her response was about symptomatic scenarios. I haven't read about a child that is symptomatic, having identified trauma symptoms and having change in function that was proven to be lying. So not only was it not in response to what he asked, it certainly wasn't, it was directly to the contrary of what he was asking. In other words, this was the expert's chance to make points, regardless of the question that was asked.
Counsel, can I ask you, let's assume for a moment we weren't of the view that this was invited error. Would you agree that at most our review would be under the plain error standard? Because if the concern was this is beyond the trial court's ruling originally, and maybe some of these answers are non-responsive to the exact questions that defense counsel was asking, then those would be objections defense counsel would be expected to make right then. Say, he's taking my cross-examination as an opportunity to make points that are contrary to the trial court's ruling and not responsive to my questions. I object, strike the testimony. That was not done. Is that true?
He did not object that, well, the government sort of brought up the strike testimony part, so we'll set that to the side for the moment. But I think that the challenge here is the dilemma that defense attorneys frequently face. At this point in the trial, there are no curative steps that could have been taken by the trial court other than granting a mistrial that would have really addressed the issue. So moving to strike would only be useful for a sufficiency issue. So for example, if you had a case where, a witness or, the key witness in a case said such and such happened, you move to strike that testimony and the court grants it, well, you might be looking at MJOA after that. That's not the case.
I understand that point, but even if taking all of what you just said as a given, why wouldn't defense counsel be required to ask for a mistrial? If what happened here is so bad and contrary to the trial court's ruling and beyond the scope of the questions that were being asked, and you're saying right now you think there was no reasonable remedy other than a mistrial, then you would think that defense counsel would object and say, this is not only is this wrong, but it's not fixable, and I want a mistrial. And defense counsel didn't do that either. Is that right?
Well, he did it later, and he did it in conjunction with things that happened subsequently in the trial that I think accumulate to increase the amount of prejudice that was faced and put this in the reversible error category.
Was the mistrial focused on the mistrial was focused on this testimony?
No, it was a combination. It was primarily based on the denial of the motion to sever, but part of that was the impact of the expert testimony with respect to, especially with respect to complainant one and count one. This goes to the absence of any issue about.
Right. Was there any, when there was a mistrial motion, was there any mention to this sequence of events in this testimony about false reporting?
I don't think he mentioned it directly in this way. He talked about the expert's testimony with he was trying to get all of it excluded, obviously. And he did talk about the expert's testimony with respect to complainant one and the need to sever because of spillover evidence and the impact of that, which is part of what the expert's issue was that he raised objections about. And then with respect to the other issues about asking for a motion to strike, you have to, the trial judge would essentially have to repeat the issue or the statement to the jury, just to point out what should be stricken, which another dilemma for defense counsel, that just sort of reemphasizes the point. If, in case you missed it, we want to make sure you hear it again and then tell you not to think about it later. The jury instructions would have been the same. Nothing would have changed on that front. And so what you're looking at here in some respect is form over substance. The issue is whether for invited error, I'm sorry, with respect to the preservation of the issue, is the desire to give the trial judge a chance to fix the problem at the time that it occurs. Based on what we see in hindsight with respect to this case, there's really nothing that the trial judge could have done to improve the situation other than granting a mistrial. And she denied that down the road anyway. So our take on this is that denying the treatment of the preservation of the continuing objection would be unfair given the specific circumstances in this case. And so that's why we're asking, at least in part, not for the plain error standard, but abuse of discretion is the standard. With respect to invited error, if I could make a couple quick comments on that. One of the things we wanted to raise with the court and be sure to emphasize was, this really wasn't an invited error scenario for several reasons. One is that, again, the questions that the defense counsel asked didn't invite the answers that were given. It looked to me as if the expert was trying to make those statements and just took it as her opportunity to get those in. And his statement that he's taking a chance by letting an expert roll, A, doesn't permit anything that comes afterwards. B, with several pages in the testimony before some of the answers that were given that were challenging here. So they were not in response to his statement that he was giving the expert a chance to roll. And the questions that he asked really were aimed at getting to the issue of whether she would give any kind of testimony about children who falsely testified, who weren't either, in the middle of custody dispute, or in this instance that she raised, suffering from severe psychiatric problems. And then finally,
I take it you would agree with me that this expert was not really qualified to testify about whether or not children make up allegations of abuse ever. Sort of that the extent to which Dr. Wolf says that doesn't happen, which is sort of an undertone of the testimony, that testimony should not have been allowed. Is that right?
We agree that testimony should not have been allowed.
So why is the only remedy a mistrial then? Why not? Is it your answer because you would have to unring a bell? I mean, it strikes me that you can unring a bell with a jury. You have heard an expert testify that children don't make this stuff up. This expert is not qualified to offer that opinion. You should not consider it in your analysis. There is nothing that substantiates that opinion. Disregard it. That to you wouldn't have done anything?
Well, a couple things. One is with respect to her qualifications, I don't know that she could have made that argument in that way. I think the cases where these issues have been raised and relief has been granted to the defense has been not that the person wasn't qualified to say that. In fact, in some of the cases we presented, they had statistical evidence that supported the position they took. And the testimony that she gave was essentially, I've never seen anything like this. And so with respect to her qualifications.
Well, then that's just irrelevant then. I mean, you could strike it for that reason too. I mean, it seems to imply that that doesn't happen. And for that, well, I'll let you answer. I don't mean to interrupt.
No problem, Your Honor. But with respect to relevance, I mean, that's fair terrain here. But I mean, the challenge is created by allowing these kinds of experts to testify is relevance doesn't come into play because the testimony is based on the fact that they don't know anything specific about this particular case. They haven't interviewed the complainants. They haven't interviewed anybody else who knows anything about the case. So relevance only comes into play with respect to their ability to educate the jury based on their prior experience and expertise. So I don't think we could have gotten it stricken on those grounds either. Really, for defense counsel, that's certainly the challenge that's been created by the line of cases, not only here in the district, but in other jurisdictions where these education experts come in and you can't really challenge them on the specific facts because their response is, we don't know anything about this case. And in fact, that ends up being reiterated by counsel in closing argument here and by the judge during instructions. The problem is that doesn't leave many opportunities for cross-examination and challenging the expert's testimony. Here in the particular instance we're talking about, the fact that she said, I don't know anything about these particular defendants, but I know that they, only children who are going through custody disputes or have serious psychiatric issues are going to falsely report, which is what she said. The jury all they need to do is add 1 + 1 and you get 2, because then they would know, well, we don't have any evidence in this case of false reports, of child custody dispute. And we don't have any evidence in this case of psychiatric problems for either of the complainants or the reporter. So what other conclusion could they draw based on the expert's testimony? And the additional layer of problem here is only this government had an expert, and this one had a Juris Doctorate. So not only was she an expert in the scientific realm, she also had legal expertise as well that bolstered her testimony here and made it more likely that a jury would be swayed by the testimony that was given.
Can I ask a question? I know this was not objected to below. This is on a slightly different topic, more to satisfy my own curiosity. But what do you think constitutes delayed disclosure here? Is it disclosure to anybody, disclosure to the parent, disclosure to the government? And what is that, a legal determination or a factual determination?
Great question, Your Honor, and it arose at 2 levels. One was how much time does it take to be considered delayed? With respect to complainant 1, all of the disclosures were made in the same day. And so what the argument the defense counsel tried to raise below was, how do you get this delayed disclosure when she disclosed to her friends immediately, to her brother later that day when she gets home, and to her mother that night when she gets there? The other aspect of this delayed disclosure is who's making the disclosure. Judge McKenna, the trial judge, sought to justify permitting delayed disclosure expert testimony with respect to complainant 1, in part because complainant's mother didn't make the immediate disclosure. But as defense counsel argued at the time, and I think it's borne out by the transcript and the record, delayed disclosure isn't about when the adults make the disclosure. It's really about when the children make a disclosure to the relevant adults in their lives or people who can corroborate it. Here, there was really no dispute about delayed disclosure with respect to why the mother waited. The expert testimony only went to the children. In fact, that's her only expertise here is with children. And so
there's another variable, I guess, which is what is the relevant disclosure? Is the concept of delayed disclosure relevant only with disclosure of the charged criminal offense? Or if there was delayed disclosure of uncharged, earlier, potentially relevant activity, could that be relevant? Because you were saying, I think, that as to complainant 1, all of the reporting happened on the day of the offense, although in several stages. But am I right in recalling that there had been prior unreported incidents that had not been reported that were not criminally charged?
I think that's clearly true with respect to complainant 2. And I don't know that they charged each and every incident, but complainant 2 made a disclosure to, I believe it was her mother, but it was like a year after the alleged incidents had begun taking place. So delayed disclosure with respect to complainant 2 we get.
And just to be clear, is complainant 2 is, can you use initials? Because I'm better oriented.
I'm sorry, LRC, the 9-year-old is complainant 2. And the 13, Sorry, Your Honor?
Right.
Okay.
I thought with
Um,
respect to the 13-year-old, am I misrecollecting that there had been some
Uh,
prior contact between them?
If I may, Your Honor, I think one of the things the government has argued, and they'll certainly be able to speak for themselves in a moment, was that there were some prior incidents that they called considered in the grooming category, but which I don't think they are alleging constituted sexual conduct that would be criminal under this provision. But certainly, you know,
I
counsel.
was trying to recall about if JM is who you're calling victim one,
Yes,
there
Your
was
Honor.
caressing of the thigh and a kissing on the lips in prior incidents.
I believe that's correct. Yes. With respect to that, I believe I don't know that those were the charged ones. I believe the ones that were charged came later. I believe
Those
it was
are
a
not
month
charged.
later.
That's why I was
Okay.
kind of raising the question is, does delayed reporting tied necessarily only to of the charged offense, or could it be relevant to a failure to report other uncharged conduct? That was the legal question I was kind of framing.
Oh, I'm sorry, Your Honor. I think the position we would take on that is that with respect to the charged offense, you know, the government's going to have to prove count one, and that the delayed disclosure there, if there's an argument that they would make about delayed disclosure with respect to that count, would be relevant information for the jury. Fair enough. But the problem with the factual basis for it is everything happened in the same day with respect to those incidents, and her talking to, I believe it was her brother, her friends, and her mother. So the argument there, and I think it's a legitimate one, is that it all happened in one day. You really don't need expert testimony about delayed disclosure there, because there really isn't any delayed disclosure.
Yeah, but I mean, the other way of looking at it is assuming that the earlier incidents are admissible, which I don't take to be disputed right now. So the jury is going to hear evidence that starting, you know, well before that day, there had been conduct that you might, as a lay person, expect would have been reported if they'd happened. And a jury might wonder, well, if it really is true that the defendant was caressing this person's thigh and kissing her on the lips, why didn't she tell anybody? And if that evidence is going to come in and a jury might wonder that, then one could think that that would be part of a delay, a set of concerns that expert testimony about delayed disclosure could shed reasonable light on. But you don't agree with that. You think the delayed disclosure has to focus only on the charged incident.
I do, unless it's, you know, criminal conduct that took place previously. I think the government ended up putting this in sort of the grooming category with respect to the expert's testimony. But with respect to the delayed disclosure type of testimony, that's not what the expert talked about. What the expert talked about was, you know, the type of acts that were contained in count one. Why wouldn't the child disclose that earlier? And what was with why would the child delay in disclosing that information? If I might, with respect to the invited error doctor, you know, the opening the door, I just wanted to double back to that for a moment. The point about the opening of the door is sort of a curative admissibility issue. And it's designed only to prevent prejudice. The way it played out in this case, though, is that it led to prejudice, because the questions that counsel asked and the statements that the doctor gave in response weren't intended to cure any kind of problem that had arisen earlier. Or, you know,
I don't think it's an opening the door issue, counsel. I mean, opening the door is when you go down a track and then your opponent gets to go down the same track because you decided to make an issue of it. That would be curative admissibility and sort of under the classical opening the door sense. I don't think this is an opening the door problem. I think it's just that you elicited, you know, not you in particular, but defense counsel at trial elicited the bits of testimony that you are now objecting to. Now, I get you say, well, maybe it wasn't super responsive. It strikes me as fairly responsive, though. I mean, you are asking generally about, you know, what goes into children making this stuff up. I think you have invited the universe of things an expert might say to that, including, oh, counsel, you're mistaken. Children do not make this stuff up, except in these rare circumstances. So I don't mean it as an opening the door issue. I mean it as an invited error issue, and I think we need to keep them distinct.
Well, with respect to that, Your Honor, again, I think the counsel asked questions that were aimed at, you know, trying to direct the expert to answer questions about falsified statements that children might make. And at one point, actually, the expert did say that there were scenarios that she was familiar with. She said they don't happen often, but she agreed that they do happen. She followed that up with the statement later that it doesn't happen unless it's under these two circumstances. And then she talked about the terrible consequences that come whenever they make any kind of allegation. So unless defense counsel is stuck in the position of not asking any questions of the expert with respect to this, which of course would just tell the jury that, well, everything the expert's saying is true. And it would probably invite a 23-110 sort of scenario after the trial. He had to ask questions, it seems to me, and he tried to frame them in a way that did not walk the defense counsel into the path of being able to say anything about, expert children never lying.
Well, if he was trying to do that, he wasn't very effective. I mean, the question, one of the sentences you object to, I think, in particular, the question that precedes it is, okay, so tell me, what are the factors? And that seems to me, if the expert's information is, there are only two factors. Those are the only two I'm aware of. One factor is custody. Another factor is psychiatric disorder. Those are the only factors I know. It seems to me that the question 100% calls for that information if that's the information the expert has, and it wasn't in any way designed to kind of avoid that answer if that was the substantive information the expert has. It was designed to elicit if that was the expert's information.
Well, the sentences we're objecting to weren't those answers weren't in response to that. What I don't hear the defense counsel is what is it that can be used as factors to help determine how these children who might present exactly the same way or be without symptoms and are lying and put somebody in a touch position. That's the question. And she says, I've never seen a child. I haven't read about a child that's symptomatic.
That's one of the questions. I thought you were objecting. Am I mistaken? I thought you were objecting to the answer to the question I just mentioned to you, where the expert says, I don't have an exhaustive list, but what I can tell you is that typically there's a false allegation, the ones we know of, custody related, it's only happened a few times, I've seen that, or psychiatric. I thought you were objecting to that. Are you not objecting to that testimony? That testimony is fine as far as you're concerned?
Well, less so because it's less definitive, but the ones that we did raise.
I'm just asking, are you objecting to that or not objecting to it?
Well, we raised it, Your Honor, as sort of a predicate to the ones that we thought were most problematic. Like the one I just read. Haven't read about a child that is symptomatic, having identifiable trauma symptoms and having change in function that was then proving to be lying. That's a problem because there's no, sometimes there's no maybe, or it happens rarely. That's period. And then the other statement that bolsters that, very unusual for any child to want all of the terrible consequences to happen. And that goes to her comments about even when children are telling the truth. So the combination of those two, I think really leaves the jury in no other place but that, well, these two kids must be telling the truth because she's never seen it happen. And, we don't have any kind of child custody dispute and they're not psychotic kids. So what else could it be? So that's what we, truly raise is the main problematic statement with respect to her testimony. And then we also raised the issue with respect to the prosecutor using the testimony that was given. The phrase she uses, ring of truth, but essentially to corroborate the statements that the testimony that was given by complainant 1 and 2 in closing argument, once in rebuttal, which didn't leave the defense a chance to respond to. So we thought that the combination of the expert statements, the prosecutor using that information in closing, to corroborate the testimony of the complainants based in part on the expert's testimony, which crossed the judge's line, and then the denial of the motion to severance and separating these kinds of issues and others out from the jury so you avoid the spillover effect. All of that together, we thought raised this case to the level where, the error was so prejudicial that it needs to be reversed and he should be given a new trial.
All right. Thank you, Mr. Ivey. We reserved a couple of minutes for rebuttal, and now we'll hear from Government Counsel, Ms. Gabriel.
Thank you. May it please the court, Elizabeth Gabriel on behalf of the United States. I'd like to first address the false reporting testimony, and then I'll turn to the delayed disclosure testimony. I think it's fairly clear from the record that the false reporting testimony was absolutely invited by defense counsel here. And by all appearances, defense counsel had made a strategic choice to introduce this topic. He came armed with cases of alleged false reports. He not only opened the topic, but he pressed Dr. Wolf on it for over the course of 8 pages of transcript, demanding answers from her. He in fact used her responses in his closing argument to support his argument that she was biased and not credible. So this was, this was absolutely invited by defense counsel, and he shouldn't be now heard to complain about it. Even if this court were to find that it wasn't invited, the fact that there was no objection means that review is only for plain error here. And the testimony did not amount to error that was much less error that was plain or obvious. Dr. Wolf did not comment on the credibility of the victims in this case. She did not comment on whether they were victims of sexual abuse. And it was clear to the jury that she had absolutely no knowledge about the facts of this case or these particular victims. So not only was it not error, but it certainly couldn't have been prejudicial to appellant. I can turn to the issue of delayed disclosure unless there are questions about that first issue. The delayed disclosure.
I guess, do you want to react to defense counsel, appellant's counsel's argument that really these statements are not so responsive? What factors go into this to respond? Well, I've never seen a child lie. I've never seen a child in my experience that was proven to be lying. I haven't seen that. Not incredibly responsive to the question.
Well, I don't agree that it wasn't a responsive response. I think that, when we look at the course of questioning, defense counsel repeatedly asked her to comment on the factors associated with false reports. She offered her, testimony on that topic, and he kept pressing her for an explanation of these 3 cases that he had brought up. When he was apparently unsatisfied with her answers, she told him all that she could based on her experience and what she had read. And it was her experience that, that children who present, she had never seen a child present with symptoms who was later proven to be lying. So I think that was responsive to this persistent questioning and demand for an explanation. And ultimately, her response was essentially that, look, the presence of symptoms is what generally suggests that there is abuse. And that's what we see in abuse cases. She did not testify, and she did not suggest that, that the fact that victims may have symptoms means that they were abused. In fact, she made very clear in her testimony that the presence of symptoms may not be, it may not mean that there was abuse, just like the lack of symptoms doesn't necessarily mean that there wasn't abuse. So she made very clear in her testimony that there's a range of symptoms, and sometimes you don't see any symptoms at all. And it's very difficult to see how the jury would take her response, this challenged response, and conclude that, oh, well, because these victims had symptoms, they clearly must not have been lying. So I think that, to answer your question, I do think Dr. Wolf's testimony was responsive to these very open-ended and persistent questions about the topic of false reporting.
I mean, I guess let me just ask about the content of the answer then. Because you're right. You know, I've never seen anybody with symptoms who's been proven to be lying. In one sense, you know, I think kind of on a lawyer's reading of that, we all understand, well, you know, it's pretty tough to prove that somebody's lying about something like that. You know, there are ways to do it, but it might convey to me, well, this expert is, you know, we don't have controlled studies of child sexual abuse for ethical reasons, right? And so it's really tough to disprove that, and I haven't seen it. Another way of reading it, though, is probably the way that she intended to convey it, is that lying doesn't really happen. I've never seen it, hasn't been proven. I don't think it exists outside of these narrow circumstances. Do you think if that was put so bluntly, which I think it might fairly convey, that is appropriate testimony for the expert to testify about?
Well, first of all, I want to push back a little bit on that. I don't think that that's how this testimony could be read. She says quite clearly that it does happen, but it is unusual. That was her testimony. It does happen, and there are cases of it. And she pointed to the literature, the research that she had read, and her own experience where she had seen cases of false reports. So, in that respect, I don't think that this testimony would have been misconstrued by the jury.
Can you just break it down for me then at page 159? I have never seen a child in my experience. I haven't read about a child that is symptomatic, having identifiable trauma symptoms, and having change in function that was proven to be lying. I haven't seen that. What about that do you think isn't relaying, conveying to the jury where you've got these trauma symptoms, lying doesn't happen? I haven't seen it. I haven't read about it.
Well, I mean, first of all, I think she's speaking to her own experience. I haven't. That doesn't mean that.
Read about it.
And well, she hasn't read about it, but she doesn't say, that doesn't mean that, it would never happen or it could never occur, right?
And she doesn't say it, but it kind of feels like she's conveying it.
But she agrees with counsel that there are cases of false reports. She doesn't say that, look, children never lie. She doesn't say that. She said, yes, it does happen. And there are studies and there's research about that phenomenon. So, I don't think that her statement here can be read as sort of an absolute statement on the credibility of child victims.
Ms. Gabriel, why isn't this a case where the trial court shouldn't have just sua sponte limited or stopped or given it some kind of warning? It seems like the trial court took care to preclude the government from eliciting certain testimony. And maybe this goes to the whole discussion that we've been having about invited error, and therefore there was no duty on the part of the trial court to do anything. But could you speak to that a little bit?
Sure. Two things. First of all, it clearly wasn't apparent to defense counsel, or defense counsel didn't perceive this as crossing the line that the court had set, and didn't perceive it as prejudicial, apparently, because he didn't object or move to strike or ask for any curative instruction. Second of all, I think that, the testimony here was put in such general terms that it just wasn't a comment on the credibility of these victims. She didn't connect her testimony at all to the circumstances of this case. She clearly didn't know anything about the circumstances of this case or these victims. And, I think this court in Oliver noted that where an expert doesn't make that direct connection, doesn't connect it up to the facts of a case, it just doesn't, it doesn't rise to the level of error. It's certainly not prejudicial error.
I mean, what if the testimony were, I don't know anything about this case. I don't know who these victims are, complainants are, but I'll tell you one thing: children under the age of 10, they don't lie. They don't make this stuff up. I assume you would say, well, that is pretty directly opining on the issue with regard to the 9-year-old in this case, right? You know, you don't need to connect it all up for the expert for it to be a pretty direct opinion on the case, right?
Yeah, no, I mean, I think that would be a much tougher issue. Absolutely. I mean, I think that that's could be taken as more directly a comment on the credibility of the witnesses, but that's not what we have here.
I mean, the way I read it is sort of like if they have identifiable trauma symptoms, if they're symptomatic in that way, well, then they're telling the truth. And if that's, I don't know what the other evidence was that they had trauma symptoms. I assume there was some. It's not quite the person's under 10 years old, that easy to put together, but it might not be that much harder to kind of put 2 and 2 together on that.
Well, but she also says, you know, the presence of symptoms doesn't necessarily mean that abuse occurred. And defense counsel questioned her extensively about, you know, her sort of, you know, one size doesn't fit all testimony that, you know, the presence of symptoms doesn't necessarily mean that abuse occurred, and the absence of symptoms doesn't necessarily mean that abuse didn't occur. So there's, you know, symptoms can be, you know, suggestive of many things, I think was, you know, basically the gist of her testimony, but it is something that clinicians look at to determine whether there was abuse. And so, you know, she certainly was not, you know, definitive in her testimony that, oh, well, where you see symptoms, boom, that's definitely, you know, that's a case of abuse. She didn't convey that at all. All right, I can keep discussing that, or I can turn just briefly to delayed disclosure. I just wanted to comment briefly about this, that you know, there was testimony here that JM did not immediately disclose to her mother, although she did disclose the same day about the touching of her breast. You know, the jury might have questioned why she didn't tell her mother when she saw her shortly after it occurred. She saw her mother, she was clearly upset, she didn't disclose. So Dr. Wolf's testimony, we think, was relevant to explain that. In addition, as Judge McLeese pointed out, she did not disclose to her mother earlier conduct, sexually suggestive conduct, the touching of the thigh, kissing on the lips. And so the delayed disclosure testimony was also relevant to that evidence. Let's see. So, you know, we don't think there was any abuse of discretion in the admission of that testimony. I can continue to talk about that, but if I see that there aren't any other questions, I would just ask this court to affirm the judgment below. Thank you.
All right. Thank you, Ms. Gabriel. Mr. Ivey, we're going to give you a couple minutes for rebuttal.
Well, I'll join Ms. Gabriel in reading the room and keep it short. I did want to say, though, that the argument that Dr. Wolf's testimony about symptoms was not definitive, I think is just flatly contradicted by the statement that we've read repeatedly with respect to symptomatic children. That's about as definitive as you can get. You know, never proven to be lying. I don't know how much more definitive you can get than that. And I think the message really couldn't have been clearer to the jury with respect to that statement. And just briefly on a couple other points. Actually, I'll stop there. I would ask the court to look at the combination of prejudicial impact from the Dr. Wolf's testimony, the use of the testimony by the prosecutor in closing, and the impact of the sort of layering effect based on the denial of the motion to sever and grant Mr. Vasquez a new trial. Thank you.
All right. Thank you, Mr. Ivey and Ms. Gabriel, for your briefs and your arguments today. The case is submitted to us for consideration, and you're free to exit our virtual courtroom at this time.
This honorable court is now adjourned.
Thank you.